Started. Committee will come to order. The pending business before the committee is the amendment in the nature of a substitute to H.R. 1631. Who seeks recognition? Gentlelady from California is recognized.
Mr. Chairman, I have an amendment at the desk, amendment number 12.
Clerk will report.
I don't know, but it's not mine.
Yeah, it's mine.
Amendment to H.R. 1631 offered by Ms. Lofgren.
Without objection, the amendment will be considered as read, and the gentlelady from California is recognized to explain her amendment.
Thank you, Mr. Chairman. Towards the end of our markup yesterday, Chairman Issa stated that a local government entity, when adopting a code incorporated by reference, could in fact place the entire code in searchable form under the Act. It's not clear when you read the manager's amendment and the underlying bill that that is explicit. So this amendment simply ensures that this would be true under the law, that governments could not be restricted from posting the law in searchable form, as Mr. Issa suggested yesterday. I hope that we can reach this a conclusion on this that is unanimous, since it merely makes clear what Chairman Issa said yesterday after the yesterday afternoon. And with that, Mr. Chairman, I would yield back.
Gentlelady yields back. The gentleman from California is recognized.
Mr. Chairman, I have no objections to the overall intent of the gentlelady from California. We carefully worked out the definition of searchable, and so the only thing that I would say is that I'm happy to work with the gentlelady and mutual staff and agree that the same level of searchability, which is index, it would in fact be available, that would be consistent with other laws posted and, quite frankly, similar to the printed book. But I believe we can work that out, and would ask the gentlelady, based on an assurance that we would refine it to that level, to withdraw the amendment, but we would agree to having the manager's amendment before it goes to the floor.
Would the gentleman yield?
I would yield.
That is not consistent with my understanding of what you said yesterday. You said searchable, searching the index alone is insufficient. I don't think we're going to come to an agreement on that. There's no need to withdraw the amendment because that's completely unworkable and defeats the whole purpose. So with all due respect, I would request a vote on the amendment.
Okay, well, in that case, reclaiming my time, I would have to disagree with it only because if any entity, let's just say the borough of XYZ, were to take the entire entity and turn it into a product, monetized or non-monetized, it would do the same as what the opponents to this have wanted to do, which is, quite frankly, to invalidate the copyright. And so for that reason, I have to oppose the amendment. And, Mr. Chairman, I yield back.
Gentleman yields back. Who seeks recognition? Gentleman from Florida is recognized.
Thank you, Mr. Chairman. And here we are yet again. Is this our fifth or sixth time in this Judiciary Committee we've taken up this bill? And it keeps coming back, not because there is any problem to solve, but because special interests continue to want to monetize the codes. So I'm going to oppose the underlying bill, and this amendment is particularly necessary because if government entities are able to incorporate codes by reference, well, then the inability to access those codes for free in a fully searchable format impairs the ability to comply with the law. I thought the purpose of the Judiciary Committee was to try to create conditions where compliance with the law would be easier, not more difficult. Unquestionably, this amendment would make compliance with the law easier, and the underlying bill will make notice of the law more elusive and compliance of the law more difficult. And so this whole bill is a way to really screw the little guy. And that's why I'm so animated about it. And maybe like on something like the Codes Act, the venom is so toxic because the stakes seem so small. But where I come from, somebody having to pay a few $100 extra for a book that is just what they want to do to be able to understand what the obligations are that are imposed on them by elected leaders, incorporated by reference, as this amendment points out. I think the goal of the amendment is certainly an important one. And I would further note that the amendment doesn't fix the bill. And so there are a lot of these amendments that I'm going to be voting for today that are remediating against the harms of the bill, but indeed don't cure it and wouldn't earn my vote for it. The only reason we are hearing this bill is because the proponents have lobbyists who make donations, and the opponents don't have an industry or an association or a lobby. That's what we're doing here. And it's pretty upsetting, and this amendment would at least ameliorate some portion of it.
Would the gentleman yield?
I will.
For a question, would you say that copyright holders are inherently special interest? Because that's who we're discussing, is the historic copyright holders, whether they've been incorporated in law or not. The advocates for retaining some part of their copyright are the copyright holders.
I would concede that copyright holders want to retain their copyright interest. I don't know that that would make them a special interest with the full pejorative that I intend.
I appreciate. Would you further agree that inside every single product, including this one, an Apple 15, there is copyrighted material?
I would.
And would you agree that if we invalidate these because they're essential to complying with the law, that in fact the next step would be to invalidate the copyrights of every bit of the machine language and copyrights, because in order to make changes or to fully use the product you bought, you would have to be able to change the copyright or own it effectively?
I would thoroughly not concede that, Mr. Issa, for one principal reason. The copyrights on your Apple iPhone aren't the law. The terms of service on Apple aren't the law. Whereas what we're talking about through these codes and how things have to be constructed or built or maintained, that has the force of law. So those are fundamentally different questions. I often side with copyright holders, with inventors in the debates that we have on these questions when it's about protecting someone's invention. But here, that invention, once ensconced in law, already has sufficient commercial exploitation for the people who are going to be able to use it.
One more question,
Sure.
if I may.
Please.
Would you agree that the FAA produces regulations that have the force of law?
Indeed.
So in order to comply with those regulations, if you want to make a product or use it, you have to make or use the patents and copyrights that are incorporated that are what we would call standard essential patents. Is there any reason that if we invalidate these copyrights because they're incorporated in law, that we wouldn't invalidate all the patents that are incorporated in law as standard essential patents?
No, I actually think the more apt comparison to this bill would be as if you had the FAA incorporate by reference how someone had to operate an aircraft within a particular area and then charged people to access that regulatory dynamic. So I think the more apt comparison would be limiting people's access to the law and not protecting the inventor. I see we're out of time, but I sense we'll have a lot of time to continue this discussion.
Gentlelady from North Carolina is recognized.
Thank you. I just want to speak in opposition to this amendment and remind people that the underlying bill, as amended, requires that any standards incorporated by reference be made available online in a readily accessible format in a location that's easy to get to, together with a table of contents and an index for free. For free. And as a result, the average citizen will now have the same access as if they had a physical copy of every standard in hand, something they might otherwise have to pay for today. And by the way, the physical copy is not searchable and all these other things. It's a piece of paper, just like, when I went to law school and we didn't have any of these things. In exchange for this dramatic increase in public access, The underlying bill allows standards creators to retain some, but not all, of their copyright's value by preserving a functioning marketplace where professional users will continue to license access to these standards. And the professional users are the ones who are going to be looking at it every day, might look at a different thing, need to get immediate updates, and are willing to pay for that. And while a professional electrician, for example, could read the electrical code in a read-only version, that person more likely would have an incentive to pay for an electronic subscription, much like lawyers pay for LexisNexis, so that they can search things, so that they can get the immediate updates, so they can see references, so they can see when things have been challenged. This amendment would undermine the professional market for these standards, which is really the only reason why these professional folks put the standards together in the first place. And then that would undermine the incentive to create the standards, update the standards, and protect public health and safety.
Would the gentlelady yield for a question?
I'm not going to yield because you've had quite a lot of time to make your point
Just a
over the last
question.
4 hours. 4 hours.
All right.
I think it is very important to remember when people have a copyright, that's an exclusive right. This law is giving away for free part of an exclusive right. If you don't allow people who have a copyright to retain any property interest in it, again, to my point, it's a taking. It's the same thing as a local government or a state saying, your land is good for our freeway or our public transit system, but then compensating you for it and having you have the ability to talk about what its fair value is. If a local government or a state was actually going to pay a license fee and then extend that license to the entire public, we would not be having this discussion right now. We are having this discussion because private entities that deal with our health and safety every day use their money to come up with standards. And then, because they're better at it than lawmakers and local governments then adopt it. And that's a great service, but it's not a free service. This bill makes everything that is incorporated by reference free and available. But that doesn't mean they have to do it in the way that absolutely everybody can do absolutely everything that they want to do with it and that other people can monetize it. That is a violation of copyright law, it is a violation of property right law, and frankly, it is a violation of our Constitution because intellectual property is embedded in our Constitution. Taking things from other people and giving them to other people for free is not embedded in our Constitution. As a matter of fact, that's why you get compensated when the government takes something. So I think we just have to get down to the basic thing about this bill. This is giving people something for free that they've never had. That's a good thing. And so I commend my co-sponsor of this bill, and I commend the bill to you, and I urge my colleagues to reject the amendment, and I yield back.
Mr. Chairman,
Gentleman from Kentucky is recognized.
move to strike the last word.
Gentleman is recognized.
I was interested to hear the question from the gentlelady from California, so if she wants to ask it,
I appreciate that, but I think we've thoroughly flushed out the questions here. And I would just note that, yes, copyright is in the Constitution. It's very important. But so is due process of law. So is the First Amendment. And the courts have found in numerous cases that the law should be free, that it is not consistent with the Constitution to require burdens on access to laws, as Chief Justice Roberts indicated in a recent case. So with that, Mr.
I'll reclaim my
I
time.
would yield back.
Thank you. I yield to the gentleman from Florida.
Thank the gentleman for yielding. It is bamboozling to hear someone make a constitutional argument about this, because the people who talked about intellectual property and invention and this great American class of thought that was being carved out of a wilderness, they never would have contemplated the ability to copyright a law. That's what we're talking about. They were talking about creating a new widget, not creating a new law that you would then have the ability to copyright. That is a crazy argument. I'm sorry, it is just a crazy argument. And then I think the argument that the gentlelady made previously was the real argument. She said, well, she opposed the amendment because the amendment limited the commercial exploitation of the codes. And so that's it. I mean, we're going to have a lot of debates here. We're going to have debates about a lot of different groups. But the fundamental question is, should laws be able to be copyrighted? And should people be able to commercially exploit the codes that they create that people have to comply with? And I cannot imagine if we were having this debate in Florida or Kentucky or Ohio or California or Maryland on any main street, as diverse as our districts are. I can't imagine if we put this bill before regular Americans that they would side with the proponents. I think just regular folks confronting this would say, well, of course, if you invent something, you should have the right for that invention to be subject to your commercial exploitation. But if the thing you've invented is required compliance by the government, that should be free to everyone to access with no commercial exploitation. So yes, I support the amendment because the purpose of the amendment is to limit the commercial exploitation of the law. I yield back to the gentleman from
Mr.
Kentucky.
Massey, would you yield for a question?
Yeah, let me say something very quickly, though, and use a little bit of my own time. I think one of the principles of this country is that the laws aren't secret. I mean, there were secret laws in countries before ours was founded, and I'm sure there are countries where the laws still are secret. How do you comply with a law that you can't completely know? Now, we're in the weeds, or we're at the fine point here of saying, well, we're going to create different classes of access to the law. If you have $10,000 to spend, then you can get an easier access to the law. Now, if you have a little bit, if you are in the moneyed class, you have more access to the law. So we're creating strata, where we're trying to preserve this, some abilities to copyright the law, which I think is wrong. I agree with the gentleman from Florida. Shouldn't be able to copyright the law. But the fallback position now is to create different categories of access to the law. And that if you're a member of some club, that you have better access to the law. And I have a real problem with that. And I would yield some time to the bill's sponsor.
Thank you. I just want to ask a couple questions because you're one of the few people. Mr. Gates says, that some assembly required is where he draws the line, but you're just the opposite. You do a lot of your own work, and you, in fact, have used in the past one of these books that you told us you borrowed from one of your relatives to do your work at home. And so I just want to ask a question so that people understand the characteristic of these books. Are these books strictly a law book, or are they basically a how-to manual?
Well, the book that I got, by the way, I didn't have to agree to any terms and conditions.
No, relatives usually will loan you their book without terms and conditions. That's true.
Yeah. So the way the book worked for me is if I wanted to comply with the law, I was able to look in the book and see what you would have to do to comply with laws in various jurisdictions.
Right,
So it wasn't a law that applied in my jurisdiction, but it was a law that applied in other jurisdictions, so I consulted it.
Would the gentleman yield?
I'll yield to the gentlelady. Oh, I'm out of time, I suppose.
Well, I would just note that
I will claim the time and yield to, for the continuation, the gentlelady from.
I would just note that the question makes a very good point, because we're talking about making sure that the law is free. But if there's manuals, if there's instructions, if there are other things, That's not the law. And the entities that are creating these standards are free to sell all of the manuals and instructions and the like, just as LexisNexis, you can't copyright the code, but LexisNexis annotates the code and does other things. They can charge for that. So I think the point made by the question is a valid one. These SDOs will make plenty of money with instructions and manuals and the like, and I wish them well. I mean, I'm not hostile, certainly, to any of them. I'm just in a position where the law should be freely available to the public, and I thank the chairman for yielding to me.
Gentleman from California. Yield to the gentleman from California.
I thank the chairman. Well, I'm going to make a point here that directly, in my opinion, the National Electrical Code that I have in front of me, it is not a recitation of the law. I want it to be clearly understood. What it is a how-to manual. If we were writing a law, we would write a law that said you have to safely install electrical in a way that will not harm people. Then you'd just have to go figure it out for yourself, because this code, reading it, any normal reading of this book by anyone, and I could start, if we had unlimited time, which I hope we don't, I could talk about damp or wet locations. In damp or wet locations, equipment, enclosures, boxes, conduit bodies, fittings shall be placed or equipped so that to prevent moisture from entering and accumulating. Now, that's not a law. That's a guidance. That's explaining to people how to. These books are, in fact, far greater than any law we would write. And that's the reality is, if we fail here, and I'm talking to these people who produce these extensive manuals, I'm going to say, look, reject anyone using your book by reference and say, write your own darn law, and guess what? We'll just sell the books that every fire marshal takes and every inspector takes and says, you know what? I'm going to use this as my guidance to whether you executed the law properly. That's what we would have had if not for generations of this kind of production that has been far more meaningful. And I will say one thing, Mr. Chairman, we are dealing with a legacy document and a changing industry, and we are trying to reach a compromise. We have a taking in this bill of what is, in fact, other people's intellectual property, and we've agreed with the industries, not big, fat, rich industries, but nonprofits, that they would agree to a partial taking. They will make their information online available for free, roughly the same as if you had the book, but they would like to continue to do the value-added sales so they can pay for, in their nonprofits, the ability to continue to do this.
Would the gentleman yield?
Just one moment, it's not my time. This is the compromise we're proposing. It is a compromise that, quite frankly, if I were in the industry, I might say, you know what, I'd rather go it a different way. But they've agreed to do it because they're public service organizations. They exist for the public good, and they want that. So, Mr. Chairman, yes, I oppose this amendment because this amendment would strip them, be a full taking under the Fifth Amendment that is wrong. Okay, and I'm not going to be a person here who invalidates people's copyrights simply because cities find it convenient to use an extensive how-to manual as a reference. But I will tell you, nowhere here in this book does it say if you don't do it a certain way, you will go to jail. It actually simply provides the guidance that then inspectors use to see whether you complied with the guidance. And I yield back.
Mr. Chairman, would you yield for just a brief comment?
Lady, yield to the
The
gentleman.
whole point is these standards incorporated by reference have the force of law. And to use the gentleman's example, if someone is constructing and does not follow the law as incorporated by reference, and my house catches on fire as a consequence, I could sue the builder for not adhering to the requirements of the law. So it's not just a manual, it's a requirement, it's the law, and that's the whole issue, and I thank the chairman for yielding.
Excuse me, who seeks recognition? Gentleman from Maryland's recognized. Darrell, can you take this?
I want to make sure I'm understanding what's being said here, because basically, I think two different things were just said. One was that, let's stick with the electricity example. If it's incorporated and it's a matter of law, which I guess is one side's argument, and it's not complied with, and the house burns down, that's one thing. If it's not incorporated to the point where it has the force of law, let's take Chairman Isa's point. I suppose whoever drafts this could say, okay, if you're not going to allow us to be compensated for this, if it's incorporated in the local statute, you can't use it in that way. So the local government then says, okay, fine, and it does the statute in the way that the Chairman Isa suggested, which is a generalized statement. And then someone's house burns down. And then there's a lawsuit. The lawsuit could say, not that this was as a matter of law, there was a violation, but that you violated the industry standard. Whether the electricity manual's been incorporated as a matter of law or not doesn't determine what the industry standard is. You could have an industry standard independent of what the law is. So is this or is this not, when they incorporate it, is it actually legal? This is the law now, or is it just a reference made by a local law or state law?
Would the gentleman
would,
yield?
yes.
Because the whole point is the statutes incorporate by reference these standards, and by doing so, they become part of the law. I use the example of suing if the standard wasn't adhered to, but theoretically, if someone failed to follow the law, they could be prosecuted. I mean, if the entire apartment building burned down and people died, you could be prosecuted for not following the law. So that's why it has the force of law. It's not a manual, it's not a suggestion, it's a requirement. It's been incorporated by the governing body, and that's why, I mean, we have a disagreement here on what the access should be. I stay with the Supreme Court that the law should be free, but there's no question that it is part of the law. I think we just disagree about how access should be made to the law, and I thank the gentleman for yielding.
If the gentleman would further yield.
I would.
Like Mr. Massey, I've got a lot of do-it-yourself time. And when I do it myself, I sometimes get a permit, I sometimes don't. When I go to get a permit, the permit is a relatively simple document saying I want to build, something onto my house, or I want to enclose something. After I get done building it, or during the process, I am required, and this is true of almost everywhere in America, if not everywhere, you post the permit, and the permit inspector comes and inspects to see whether the work is solid. That person is a craftsperson trained individual who ascertains whether or not you've done it according to, if you will, code, but also according to good practices. They look at, for example, flashing on windows to see whether they're likely to leak and so on. And they sign off on it, and that's the end of it. And that's true of electrical, that's true of water and pipes and gas and so on. The reality, though, is this book, for 100 years, versions of it have been used to help people make a decision on how best to do it. But I will tell you, any clear reading in it, you see that it's much more and much different than a law. It is a how-to. If we were writing laws, and I'll just say it one more time, if we were writing laws, the laws would not be 1,000 pages just for the electrical code, and similar for fire safety. And fire marshals, instead of having this kind of a guidance to see whether somebody is living up to it, not just their opinion, would in fact not be able to do their job. So both the fire marshal, in the case of that standard, and those who are building for fire safety, they use it to help them do it. By the way, Mr. Ivey, they still sometimes disagree, and the fire marshal wins, regardless of what this book says, if he or she says it's unsafe. So to say this is the law is inaccurate on its face. To say that it is referenced as a guide is accurate, and I think that's what we have to recognize.
Let me reclaim my time quickly. If we're saying this is, well, Could the people who produce these documents, who apparently are not compensated by city, state, or local governments, say, well, look, if you're going to incorporate it in the statute and not compensate me, I'd rather not have it incorporated so that then people have to come out and buy my books.
Would the gentleman yield?
That is absolutely true.
That would be correct, but the fact is, these organizations are lobbying the legislative bodies to incorporate their standards by reference. This is not unwillingness, this is
Yeah, but I
generally
mean, the
lobbying.
question, and I apologize for running over, but the question is, if we do what you're suggesting, and I'm referencing the gentlelady from California, and then these companies say, well, you can't use what we produce, what happens then? How does it move forward? If you're saying that we're not going to allow we're going to allow anybody to have access to all of it for free, if it's incorporated in the law or referenced by a law, and I apologize for running over, and they say, okay, well, you can't incorporate it, but whoever's, the electricians and the plumbers or whoever still have to go get the book and follow the code. How does
It's
that
not the
accomplish
code
what
if it's not incorporated.
Well, it would be a code of a sort if it's not.
It would be a
incorporated.
professional standard.
Yeah.
I'll just note that, since 2022, when they lost these cases in court, and the public interest group started posting them with access for free, the revenue into these standard setting organizations went up. It didn't go down, and they didn't stop. I mean, theoretically, you could say, well, you have to compensate, but that is not what has happened. They are lobbying to have this incorporated. They're making money. The American Standards, National Standards Institute made $88 million since the court ruling, and good for them. I'm not opposed to that, but they're selling manuals, they're selling other instructions. It's a theoretical problem that is not actually rooted in what the experience has been since the court decision.
I appreciate the dialogue. Does anyone else seek recognition? If not, the question occurs on the amendment to the amendment in the form of a substitute. All those in favor say aye.
Aye.
All those opposed say no. No. In the opinion of the chair, the noes have it. The noes
Would request a
have it.
recorded vote.
A recorded vote being requested. The clerk will call the roll.
Mr. Jordan. Mr. Jordan.
Mr.
Mr.
Chairman.
Jordan votes no.
Mr. Chairman,
Yes.
which amendment are we voting on? Is that number 12 or
Yes.
something?
Lofgren, number 12.
Okay, I apologize.
No, that's fine. No from me.
Mr. Isett votes no. Mr. Gates. Mr. Gates votes aye. Mr. Biggs. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Massey. Mr. Massey votes aye. Mr. Roy. Mr. Bishop. Ms. Sparts. Mr. Fitzgerald. Mr. Bentz. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Gooden. Mr. Gooden votes no. Mr. Van Drew. Mr. Van Drew votes no. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Ms. Hageman. Ms. Hageman votes no. Mr. Moran. Ms. Lee. Ms. Lee votes no. Mr. Hunt. Mr. Fry. Mr. Nadler. No. Mr. Nadler votes no. Ms. Lofgren.
Aye.
Ms. Lofgren votes aye. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Shiapal. Mr. Correa. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Escobar. Ms. Ross. Ms. Ross votes no. Ms. Bush. Mr. Ivy.
No.
Mr. Ivy votes no. Ms. Ballant. Mr. Armstrong. Mr. Armstrong votes no.
Anyone else seek to vote? The clerk will call the roll, or will report.
Mr. Chairman, there are 13 ayes, 3 ayes and 13 noes.
Mr. Chairman?
The amendment is not agreed to. For what purpose does the gentlelady from California seek recognition?
I have a number of amendments that I would like to consider en banc.
Without objection,
as
they will be
asked
considered
for
en bloc.
yesterday.
Object, I'm not for doing en banc amendments.
All right.
Are you sure you want to be dilatory, Mr.?
Well,
Mr.
Mr. Issa, it's not, I actually think what's more dilatory is considering amendments en banc in such a manner. I think it's more deliberate to go through them, not dilatory, and I don't appreciate the characterization.
If the gentlelady would like to combine them, they become one amendment. That would be the gentlelady's prerogative if she wanted to join them into one amendment. Otherwise, there has been an objection.
You know, I can go through them, but I do think there are a number of amendments that call for GAO studies on the impact of this bill. I had intended to combine them, but while I ponder that, let me...
I have an amendment at the desk.
Yeah, would the gentlelady take time to do that, and we'll consider the other amendment if you don't
Sure.
mind? I thank the gentlelady. For what purpose does the gentleman from Florida rise?
I have an amendment at the desk.
The gentleman has amendment desk. What is the amendment number?
I don't know, but
Does the clerk have?
it says
the
number 1, I believe, on it. Gates 1, is that correct? 2, perhaps 2. Yes. 2.
The clerk report.
Amendment to H.R. 1631 offered by Mr. Gates of Florida. Amend line 20 on page 8 to end in a comma and after the comma to insert.
The gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. This is an amendment for America's veterans, to ensure that Americans' veterans and veteran service organizations and veteran-owned entities are not subjected to the punitive provisions of this bill that require people to rent the law. If people are going to have to rent the law, I think veterans and veteran service organizations should be exempt. I represent the district in the country that has one of the highest concentrations of veterans, and what I know about this class of inspiring and patriotic folks is a great many of them are do-it-yourselfers. They like to go out and fix their own air conditioner and put on their own roof and make their own deck, and so it's a group of people who I think are uniquely susceptible to the evils of this bill. Moreover, there are a lot of veteran service organizations that provide ramps for people, that go help with improvements, widening doors. They've done this in my district to combat wounded veterans, and I don't want to be in a situation because the sons of AMVETs didn't rent the law the way this bill contemplates, that somehow they would have damages sought against them from a state or a local government.
And would the gentleman yield?
Yield to the gentleman.
Yeah, in my district, they've built entire homes for wounded veterans. And I think it would be a shame if we extort the people who are trying to do good for the veterans by building houses or, as the gentleman mentioned, access ramps. And so I support the amendment. I yield back.
No, I thank the gentleman for making that note, and it's heartwarming to hear that there's actually a tremendous growth in veteran service organizations providing these services to vets when, and frankly, it's having to happen oftentimes because the VA has been so inefficient at getting someone an extra ramp or a raised toilet seat or an arm bar for transfers when people don't or have to deal with some form of paralysis. So I think that's really important, not just to protect the veteran, but moreover to protect the veteran service organization. And I also want to point out that the way the amendment functions, it's a prohibition against seeking damages against veteran service organizations, veterans and veteran-owned businesses. And I think that's really important because it's the most punitive feature of the bill is that government entities can seek some sort of damage against people, can haul people into court, and can make them have to confront that lawfare. And so my hope is that the amendment would deter that and would ensure that our veterans were able to continue the great work that they're doing in our communities. I yield back.
Gentleman yields back. For what purposes does the gentleman from New York seek recognition?
To strike the last word.
The gentleman's recognized.
Mr. Chairman, I rise in opposition to this amendment. veterans are a very sympathetic class of citizens, obviously. And we deserve a great deal of gratitude for their service to this country. But we don't make exceptions to copyright laws. Not for any group of people. If someone has a copyright, they're entitled to enjoy the advantages of that copyright. We don't make an exception for veterans or firefighters or police officers or members of Congress or anyone else. So this is a very pernicious amendment. It strikes at the heart of copyright law, and I urge its defeat. I yield back.
Gentleman yields back. Anyone else seek recognition? The gentleman from New Jersey.
I've been supportive of the underlying bill, and I'm going to digress just for a second, but it's my 5 minutes. I have a piece of legislation that would ensure that these VSOs are never charged more for broadband, cable, et cetera, than the residential rate. I don't know if folks know, but veterans organizations are also often charged the commercial rate by Comcast and other countries. Man, I'm getting all kinds of aggravation about it. And this goes to my issue of, we talk in the talk or we walk in the walk. There are exceptions. Life is full of exceptions. I think this is one of them. I'm going to support this amendment. I yield back.
I'll recognize myself for just a few moments. Panama City is not in the gentleman from Florida's district, but it is home to many of my friends who served decades in the military. Most of them were Army helicopter pilots and officers, many of whom, including one of my friends, Mike Antonelli, today has, for the 10 years since his retirement, continued to build housing for veterans specifically, and that's something that he's been very involved in since his retirement. He uses these books, there's no question at all. But he was an Army aviator who went into doing this kind of work, and these books were incredibly helpful. Yes, they cost a few dollars, but they also were, like our aviation training, not free, but in fact a great value. As someone with 10 years of active duty and another 10 in the reserves, I know that we veterans don't want anything that we didn't earn. The fact is, we, in fact, want to pay our fair share in everything we do, and I think that's the story. So I agree with the ranking member of the full committee that, in fact, we don't make those kinds of exceptions. We do provide, and many organizations provide voluntarily discounts and other opportunities for veterans, including the skills training that often veterans get from the very organizations that help produce these manuals. So I am opposing the amendment. I don't believe it serves us well to start carving amendments, particularly knowing that copyrights somebody can buy something for a veteran, somebody can help do it, and those homes that were built for veterans were built with money that people gave for that purpose, not by simply saying, well, you get a free house. You don't get a free house. The fact is, I contribute and others contribute to the organizations that do that for the men and women who have given so much for our country. And with that, I yield back. Does anyone else seek recognition? If not, the question is on the amendment to the amendment and a substitute offered by the gentleman from Florida. All those in favor say aye.
Aye.
Those opposed, nay. No. Nay.
I'll request a recorded vote.
A requested vote being ordered. The clerk will call the roll.
Mr. Jordan? Mr. Jordan votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Gates? Mr. Gates votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren?
Aye.
Ms. Lofgren votes aye. Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant?
How is Mr. Johnson of Georgia recorded?
Mr. Johnson of Georgia is recorded as no.
Thank you.
Mr. Massey, you're not recorded. Mr. Massey votes aye. Mr. Biggs votes aye. Mr. Armstrong? Mr. Armstrong votes no.
Anyone wish to change their vote? The clerk will report.
Mr. Chairman, there are 5 ayes and 11 noes.
The amendment is not agreed to. Does anyone else seek recognition? The gentlelady from California is recognized.
Mr. Chairman, I am in the process of combining a number of amendments. I understand Mr. Gates's concern, but I think we can deal with them in a professional way. While that is happening, I would like to call up Amendment 23.
The clerk will read the amendment.
Amendment to the amendment in the nature of a substitute to H.R. 1631 offered by Ms. Lofgren of California. Insert the following after line 6 on page 9.
The amendment will be considered as read, and the gentlelady is recognized to explain her amendment.
Mr. Chairman, this amendment would ask the Copyright Office to produce a report on the Pro Codes Act. Specifically, the report would include a detailed assessment of the Act's effect on case law, an analysis of the Act's effectiveness in achieving its stated goals, a review of any challenges or obstacles encountered during the implementation process, a recommendation for legislative or regulatory modifications to improve the Act, an overview of the impact of the Act on the public, including access to legal information and compliance costs for governments, businesses, and individuals. The initial report would be submitted within 2 years of the enactment of the bill, and subsequent reports should be submitted semi-annually on the anniversary of the first report submission. I think it's important, as I said yesterday, that we know what the impact of this bill would be. The state of the law today is that you may not copyright law. That's what the circuit courts have said. That's what the Supreme Court has said. That's what the case law is. We have individuals and groups that disagree with the court. They've come to us to overturn the court's decisions. Many of us believe that even if this amendment, this bill were to become law, it would not necessarily change the outcome of the court decisions. For example, the fair use rules that the court has adopted continue to exist. They're rooted in the First Amendment, and it's not at all clear that Congress, through legislation, can alter that. I recall a number of years ago, I'm not sure anyone was on this committee other than myself and Mr. Nadler, where there was a proposal by individuals and institutions who had tried to copyright the listings on the stock market. And the court found that you can't copyright facts, right? And so we did a bill to copyright the facts, but it didn't change the fact that you can't copyright facts. And It's not clear that this bill would allow us to overcome the due process issues involved in overturning the court decisions, or the First Amendment issues in overturning the court's decisions. But I do think having a professional analysis undertaken by the Copyright Office would inform us and make us better legislators. It's worth noting that the Copyright Office last September issued a statement indicating that they believe that the current state of the law, the case law, is appropriate, that is not appropriate to burden access to the law. They disagree, obviously, from that statement with this bill. But if this bill becomes law, let's ask them what the impact is, and then we can see where we go from there.
Would the gentlelady yield for a
Would be
quick
happy to yield.
question? I have no problem with the intent of this amendment. I have one request, if the gentlelady would agree. At the very end where it says subsequent reports shall be submitted, if you would move that to every 5 years, lest we burden, they'll already be doing one at the end within 2 years. If every 5 years after that would be less of a burden to the Copyright Office, semi-annual.
A decadal or semi.
It would be, you would get one, the
Yeah,
first
I don't have a
report
problem
after
with,
two.
I don't have a problem with that, because I think that when we get the first report, we will find that the Copyright Office got it right last September.
I have no doubt the first
Current-
report will be the telling one.
The current state of the law is what should continue to be the law. But with that, I'd ask unanimous consent to change that, and
Without objection.
I would ask that the body approve the amendment. With that, I yield back.
I would ask for unanimous consent that the amendment be included in the as an amendment to the amendment of in the form of substitute. Without objection, so ordered. Anyone else seek recognition? The gentleman from Florida is recognized for
Mr. Chairman, I have an amendment at the desk.
what amendment number?
It's tagged disabilities number 2.
The clerk will read the amendment.
Amendment to H.R. 1631, offered by Mr. Gates of Florida.
The amendment will be considered as read, and the gentleman is recognized to explain his amendment.
Thank you, Mr. Chairman. This is an amendment to ensure that the punitive provisions of the bill that require the rental of the law are not enforced by governmental entities against the disabled or organizations that are principally providing for the services to people with disabilities. My mother has been in a wheelchair since I was 3 years old, and I have seen how when people who are disabled move from one home to another, there's a great deal that needs to be done in restrooms, in kitchens, to allow for the transfer from one room to another, door widening, ramping, and there are organizations who go and help people who are disabled do these things. And if those organizations don't rent the law, as the proponents of this bill would have them do it, I just don't think that you should have municipal governments, state governments, or the federal government going after the disabled for copyright damages or groups that are principally serving those communities. That's the amendment. I yield back.
The gentleman yields back. I'll recognize myself briefly. This is, again, another amendment for a carve-out that, although well-meaning, I'm sure, would effectively create a large gap where someone would simply saying, I'm doing something for somebody who has a disability, recognizing that the disabled, including your mother, deserves to have products that are properly produced and safe, and that's what these books do. The reality is anyone under this bill clearly is given full access to the code, does not get, and I'm going to be quite candid, does not get the enhanced capability that may become available in the future, but gets the ability to look at the book, read the book, search by index, and become familiar with whatever they take. So since we are fully enabling somebody to have the equivalent of having the book in their hand, something that did not exist in the past, for free, I find this amendment unnecessary. I will note that we did provide specific requirement for the producers of these standards to accommodate disabilities, and that accommodation, I think, is more than broad enough. With that, I yield back. Did gentlelady seek recognition? No. Okay. Seeing no other questions, the question is on the amendment and to the amendment in the form of substitute. All those in favor say aye. Those opposed, nay. No. In the opinion of the chair, the noes have it, the noes have it, and a recorded vote being requested. The clerk will call the roll.
Mr. Jordan? Mr. Jordan votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Gates? Mr. Gates votes aye. Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparks? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes aye. Ms. Jackson-Lee? Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. Macbeth? Ms. Dean? Ms. Escobar? Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy? Mr. Ivy votes no. Ms. Ballant? Mr. Massey, you're not recorded. Mr. Massey votes aye. Mr. Moore votes no. Mr. Biggs votes aye.
The clerk will report.
Mr. Chairman, there are 5 ayes and 12 noes.
The amendment is not agreed to. For what purpose does the gentlelady from California seek recognition?
I have an amendment at the desk, amendment number 13.
The clerk will read amendment number 13.
Yes. Mr. Chairman, this, I will note, is, number 13 is the combined previously noticed amendments of 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 24, and 25, all a GAO study.
And the chair truly appreciates that, and, well, are you prepared to read?
Amendment.
Clerk will report the amendment.
Amendment to H.R. 1631, offered by Ms. Lofgren of California. Strike, quote, period, quote.
And the amendment will be considered as read, unanimous consent, and the gentlelady from California is recognized to explain her very much appreciated combined amendment.
Mr. Chairman, I appreciate Mr. Gates's comment that en banc amendments curtail or discussion, but since each one of these amendments directed the GAO to do a study, I think we can fairly discuss what that study should consist of. First, we would direct the GAO to study the impact of the Act on historically disadvantaged communities. Yesterday, I asked unanimous consent to put into the record the amicus brief signed by the NAACP. The NAACP highlighted how inaccessible standards leave Black and low-income communities vulnerable in disputes. We should study the impact of this bill if it becomes law. We would also ask the GAO to study the cost to states, cities, municipalities, counties, and special districts associated with this bill. We know, and again, I asked unanimous consent to put into the record the amicus brief. The County of Sonoma itself paid $40,000 for copies of the state model codes in 2019 alone. It's a little county. That's a lot of money for a little county, and we should have a study of it. We'd have a study on impact on consumers, also a study on the privacy, the requirement that users provide their personal information to access the standards. That raises privacy
Would the gentlelady
concerns.
suspend
Let
for
me
a question just on the, is Amendment 12, which doesn't appear to be a study, but rather a...
We just took 12. That was the
Right,
posting.
it was in the packet, so it's not
Oh,
part
that's
of
by mistake then.
Okay, well, please, would everyone remove the first page if it says 12 on it, and we'll continue. Thank you.
Yes. We'd also ask the GAO to study the impact on the access to laws. Transparency in legal processes is foundational to public trust, and restricted access could lead to decreased transparency and lower trust in legal and governmental institutions. We'd ask for a study on the accessibility and usability standards for people with disabilities. We'd also ask for a study on the impact of affordable housing as well as homeowner cost for building code access, because a lot of these standards have to do with building, and we know that there is really a crisis in this country of lack of housing. We'd also ask for an impact on a study on the executive compensation at SDOs. Concern has been expressed by some members about the financial status of these SDOs. I would note, and I've mentioned and put this in the record yesterday, that the American Society for Testing and Materials had a $135.7 million in revenue with total executive compensation of $4.8 million. The American National Standards Institute had revenue of $88 million with executive, the CEO there made $2.8 million in 2022. So if the motive for this is to make sure that these institutions make a lot of money, let's study it. Let's take a look at the impact on small businesses, and finally, the impact on the First Amendment. In 2020, the Supreme Court of the United States reaffirmed that if every citizen is presumed to know the law, it needs no argument to show that all should have free access to its contents. By extending copyright protection, I believe the Pro Codes is unconstitutional under the First, Fifth, and 14th Amendment, which guarantees the public's right to read, share, and discuss the law. The case law is supportive of that position. ASTM versus Public Resources in the Circuit Court in 2023, as well as the Veek versus Southern Building Code, Congress International, the 2002 case cited with favorably, as well as the Georgia versus a Public Resource Organization case in 2020, where the Supreme Court addressed the issue of copyright protection for non-binding annotations in the official code of Georgia, but it reaffirmed a precedent that when officials empowered to speak with the force of law create materials in the course of their official duties, those materials are government edicts that cannot be copyrighted. So I think we ought, if this bill passes, and I hope it does not, know what damage we've done to America through its enactment. And with that, Mr. Chairman, I yield back.
As they finish reading it, I'll recognize myself for a couple of questions to the author. Does the gentlelady intend for the earlier GAO study, which was approved?
No, that was to the Copyright Office.
Oh, I'm sorry. You're right. I looked at that all the GAO studies be formed into one study with these elements.
That would be, that's why it's one amendment.
As it should be. Give me just one more moment for them to finish reading.
Mr. Chairman, as your staff is reading, the amendments are the same as they were before. They're just combined. They're not different.
And I agree. I just wanted, because we hope to accept it in block as a unanimous consent, I just want to make sure that we've gone over it one more time so we not have to make technical corrections later if we can help it. If I can engage again with the gentlelady, we're told that with the possibility of some small technical and conforming changes, that we can do it. I would ask if it's accepted that you and I meet with, assuming this becomes law, meet with the GAO to further refine it, but I have no problem in accepting in block
Sure.
all of this into one study.
Good.
If the gentlelady agrees,
I
then
do.
I ask unanimous consent that the amendment be considered as passed. Without objection, the amendment will be placed in the record as amending the amendment in the form of a substitute. Are there any further amendments? Seeing none, the question occurs on the amendment in the nature of a substitute. All those in favor say aye. No, this is on the underlying ISA amendment in the nature of a substitute. All those in favor say aye. Aye. All those opposed, no. No. In the opinion of the chair, the ayes have it. The ayes have it. The amendment is agreed to. The question now occurs on the bill as amended. All those in favor say aye. Aye. Any opposed, no. In the opinion of the chair, the ayes have it. The ayes have it. And the bill, a recorded vote being requested, the clerk will now call the roll.
Mr. Jordan. Mr. Jordan votes yes. Mr. Issa.
Yes.
Mr. Issa votes yes. Mr. Gates. Mr. Gates votes no. Mr. Biggs. Mr. McClintock. Mr. McClintock votes aye. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Ms. Sparts. Mr. Fitzgerald. Mr. Fitzgerald votes aye. Mr. Bentz. Mr. Klein. Mr. Armstrong. Mr. Armstrong votes yes. Mr. Gooden. Mr. Van Drew. Mr. Van Drew votes yes. Mr. Nels. Mr. Moore. Mr. Moore votes yes. Mr. Kiley. Ms. Hageman. Ms. Hageman votes yes. Mr. Moran. Ms. Lee. Ms. Lee votes yes. Mr. Hunt. Mr. Fry. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Lofgren votes no. Ms. Jackson Lee. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Mr. Correa. Ms. Scanlon. Mr. Nagoose. Ms. McBath. Ms. Dean. Ms. Escobar. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Klein votes aye. Mr. Massey, you're not recorded. Mr. Massey votes no. Mr. Biggs votes no.
How is Mr. McClintock recorded?
Mr. McClintock is recorded as aye.
Thank you. How is Mr. Carrera reported?
Mr. Correa is not recorded. Mr. Correa votes aye. Ms. Scanlon, you are not recorded. Ms. Scanlon votes aye. Mr. Gooden votes yes.
The gentleman from Georgia is recognized.
Mr. Johnson, you are not recorded. Mr. Johnson votes aye. Mr. Bishop, you are not recorded. Mr. Bishop votes aye.
Does anyone else seek recognition or to vote? Anyone wish to change their vote? Seeing none, the clerk will report.
Mr. Chairman, there are 19 ayes and 4 noes.
And the bill is agreed to. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Pursuant to notice, I now call up H.R. 3591, the Asylum Accountability Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 3591, to amend the Immigration and
Without objection, the bill will be considered as read and open for amendments at any point. The chair now recognizes the gentleman from California, Mr. McClintock, for his opening statement.
Thank you, Mr. Chairman. The deliberate collapse of our border and the deliberate subversion of our immigration laws by this administration is now being felt intensely in communities all across America. The Democrats have intentionally admitted 4.6 million illegal aliens into our country, allowing an additional 1.8 million known gotaways to enter as well. This is an illegal population larger than the size of the entire state of Missouri, our 18th largest state with 8 congressional districts. This is only the beginning if this administration remains in power. Gallup warned last year that from their surveys, they estimate 42 million people are intent to illegally migrate here just from Latin America and the Caribbean alone. But of course, the Biden illegal mass migration is coming from 170 countries all over the world. And the Democrats' answer is Senate legislation that would make it impossible for a future president to restore control of our borders until illegal immigration surpasses 4,000 illegal crossings every day. The core constituencies of the Democratic Party, working families whose wages are suppressed and whose jobs are taken by this flood of cheap, illegal labor, are awakening. Inner-city neighborhoods victimized by mass concentrations of illegal aliens and the crimes, drug trafficking, and human trafficking that accompanies it are also awakening. In communities across America, schools are overwhelmed with non-English speaking students. Hospitals are overwhelmed with illegal aliens demanding uncompensated care. Homeless shelters are overwhelmed and are turning away Americans needing help. Services are being cut to divert taxpayer money to support an unprecedented, impoverished, and dependent population. Fentanyl surging across our borders is destroying American life. And the Democrats not only don't care, they're actively encouraging and defending this every day in this committee and in this Congress. Under the Democrats' open border policies, an illegal alien need only cross the border, a federal crime, by the way, and claim that he fears persecution. Utter those magic words, and they know they will be automatically admitted into the country. They'll be given free medical care, free food and clothing, free snacks, free lodging, free transportation wherever they want to go in the country. Within 6 months, they'll get work authorization. They'll be given a notice to appear, in effect, an arrest warrant that will allow them to board a plane with no other form of identification. They will be given a hearing years into the future, and when their asylum claim is finally ruled to be phony, as the vast majority are, and they're ordered deported, they know that the court-ordered deportation is unlikely to be carried out by this administration. And of course, many simply don't show up for their asylum hearing, because why bother? They know as long as the Democrats retain control of our government, they can stay and wait for the next amnesty program. The number of aliens ordered removed after they failed to appear at an immigration court hearing has skyrocketed under Biden. The number's up to 13,000 every month. Now, this shouldn't surprise us. They know there are no consequences because they know the laws will not be enforced as long as this administration is in office. It will require a new administration committed to securing our border, defending our people, enforcing our laws, and restoring our nation's sovereignty to fix this. And that can only be done by the American people at the ballot box.
If they choose to do so, Republicans are putting forward a collection of new laws that will strengthen the next president's hand and increase the consequences for those who flout our laws. The bill before us is such a law. Under current law, if an immigration judge orders an alien removed from the United States after the alien fails to appear at an immigration court hearing, that alien is barred from certain immigration relief for 10 years. This bill would make that ban permanent. Although H.R. 2 provides a comprehensive plan by ending catch and release, raising the credible fear standard, mandating detention, and closing asylum loopholes, H.R. 3591, the Asylum Accountability Act, takes yet another step to bring sanity back to our immigration system. If a guest in this country who is basing their presence here on a fabricated asylum claim doesn't even bother to attend their immigration court hearing, that individual should not enjoy immigration relief under the laws that they've so willfully violated. The notice to appear is not a suggestion, it is an order. It ought to be treated that way, and this bill demands it. And with that, I yield back the balance of my time.
Gentleman yields back. The chair now recognizes the gentleman from New York to speak on the bill.
Mr. Chairman, once again, Republicans are considering immigration legislation that does nothing to address the situation at the border or to fix our immigration system. Even worse, this legislation does not actually solve the problem they say they are trying to fix. My Republican colleagues often claim, based on highly misleading statistics, that individuals do not show up to their immigration court proceedings. So what is their solution? To permanently bar individuals who are ordered removed in absentia from certain forms of immigration relief. Current law already bars such individuals from certain forms of relief for 10 years, but apparently this isn't draconian enough. Republicans continue to believe, despite myriad evidence to the contrary, that harsher and more punitive laws are the only way to fix the immigration system. The fact of the matter is that non-citizens want to and do attend their immigration proceedings. A 2021 report by the American Immigration Council found that 83% of non-detained immigrants attended all their immigration court hearings. When immigrants do miss court hearings, it is often for a good reason. In fact, one of the main reasons that people miss their immigration court hearings is because they never received adequate notice of the hearings to begin with. For example, in 2018, the Trump administration admitted in court that almost every single charging document that placed people in removal proceedings, called the Notice to Appear, that they had issued over the past 3 years did not actually list the date or time of the court proceeding. Likewise, over the past 5 years, there are multiple confirmed reports of Border Patrol agents issuing migrants notice to appear documents that list false addresses or the address of migrant shelters in major cities, seemingly chosen at random. When notice to appear documents are mailed to the wrong address, it not only sows confusion and chaos in the immigration system, but it also makes it extremely difficult for immigrants to make it to their immigration court proceedings. Instead of increasing the penalty for those who miss their hearings, we should be focused on solving the underlying issue so that individuals are not missing these proceedings in the first place. We should be exploring ways to fix the defective notice to appear documents so that immigrants actually receive proper notice of their court hearings. We should also be improving access to counsel, as that has proven to be a very effective way to ensure that folks show up to their court hearings. Only around 30% of individuals in immigration proceedings have an attorney, but 96% of those who do have a lawyer attend all their proceedings. In addition to being unnecessarily harsh and punitive, this bill is overly broad. Titled the Asylum Accountability Act, one would assume that it focused on asylum cases. In reality, however, this bill would have a much broader impact and would affect even lawful permanent residents. It would cut off important avenues of relief, such as cancellation of removal, for a green card holder in removal proceedings who merely misses a court date due to poor notice on the part of the government. Let's keep in mind that to be eligible for cancellation of removal in the first place, an individual must have been a lawful permanent resident for at least 5 years, have resided in the United States continuously for 7 years, and must not have been convicted of a serious crime like an aggravated felony. Congress should not cut off avenues of relief for people who have lived in our country lawfully for a long period of time, especially over what might have been an honest mistake, and subsequently condemn their U.S. citizen family members to such extreme hardship. Unfortunately, this legislation reinforces what we have seen again and again in this Congress, that my colleagues across the aisle are not interested in solutions on this front. They would rather have chaos and confusion in the immigration system so they can use it as a campaign issue. And if thousands of immigrants and their families are hurt in the process, so much the better. I urge my colleagues to rethink their punitive approach and to work with us on bipartisan legislation that actually fixes the problems in the immigration system. I urge all members to oppose this legislation, and I yield back.
All other opening statements will be included in the record. The chair now recognizes the gentleman from California for the purpose of offering an amendment in the nature of a substitute.
Thank you, Mr. Chairman.
Wait, we got to go to Mr. McClintock
Okay.
first.
Thank you. Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purpose of the amendment. The chair recognizes the gentleman from California.
The amendment simply makes small technical changes. It doesn't change the substance of the bill, and I yield back.
Gentleman yields back. Who seeks recognition? The gentleman from California, Mr. Correa, is recognized.
Thank you, Mr. Chairman. This amendment is a very simple amendment. While this bill is called the Asylum Accountability Act, the bill itself is much broader in its
Hang on a second. Gentleman's offering an amendment.
Yes.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 3591 offered by.
The gentleman from California reserves point of order. The amendment will be considered as read. The gentleman from California is recognized to explain his amendment.
Thank you, Mr. Chairman. This amendment, as I stated, is a simple amendment. While this bill is called the Asylum Accountability Act, the bill itself is much broader in impact. It actually bars DACA recipients from important forms of relief. This amendment would essentially exempt DACA recipients from this overly punitive bill. Sadly and unfortunately, there are a significant number of DACA recipients who were brought to this country as children that have outstanding removal orders. And this is not hard to see why this actually happens. As was said earlier, one of the main reasons people miss their immigration court hearing is because they never received adequate notice of the hearing to begin with. And that was said earlier. In 2018, the federal government admitted in court that almost every single charging document they had issued to a migrant over the last few years did in fact not have a date or time for them to show up in court. And of course, when it comes to DACA recipients, one uniting characteristic that they all have is that they did not choose to come to this country. They were brought here by their parents, and if their parents did not know when they were supposed to go to court, how can we blame their children for that as well? Likewise, if even the parents knew that they were supposed to come to court and made a bad decision not to go to court, how can we hold their children accountable for such action? So, Mr. Chairman, let's be clear about the impact of this bill. A DACA recipient who never got a notice for a hearing or didn't know he had a hearing because he was a child gets an order for removal. Do you want to essentially bar that children from key reliefs in the future? And let's remember that the kinds of people we're talking about in the principal bill here should not be part, that is, DACA recipients should not be part of this legislation. And again, let's remember who DACA recipients are. DACA recipients, to be eligible, have to have been in this country before 2008. And of course, to be a DACA recipient, you would have to have been a contributing member of our society. Many of these DACA or Dreamers are police officers, soldiers, veterans, sheriffs, nurses, and other productive members of our society. Why, in God's name, would you include them as part of this bill? Thank you, Mr. Chairman, and I yield.
Gentleman yields back. Before turning to Mr. McClintock, the committee will probably have to recess here, and we will recess here in a few minutes because the Fourth Amendment's not for sale bill is going to be on the floor. But I'll let Mr. McClintock respond, and then...
Mr. Chairman? Oh, after.
Gentleman from California is recognized.
Thank you, Mr. Speaker. The Democrats tell us that, well, many illegal aliens do attend their hearings, and some actually do. That's true. This bill wouldn't apply to them. It only applies to those who flagrantly ignore a court order. Now, the Democrats say, and this amendment pursues the notion that many illegal aliens who don't get a notice shouldn't be banned for life. But the law already provides for an alien to contest a deportation order for this very reason, or a wide range of other reasons as well. The only difference is they have to prove it in court. DACA recipients are already banned under current law for 10 years. This bill simply insists that those who come to our country and become adults have to obey the law. And if they don't obey the law, there will be consequences. With that, I yield back.
Gentleman yields back. Does the gentlelady from California seek? If we go real quick, then
I will be very quick,
Okay.
Mr. I'd like to strike the last word.
Gentleman's right.
I would just note, you know, we've often said that the immigration system is broken, and I include the asylum system in that. We need reform from top to bottom on the Immigration Act, and the premises for creating order at the border are not gone. I would love to work with all the members on this. However, this is not the right approach. I just want to mention a meeting I had a number of years ago with American citizens whose husbands had been removed. And what they did was they under FOIA, Freedom of Information Act, they asked and received copies of the files of their husbands. All of them had little notices. The notice to appear had been returned to sender because the address was wrong. In 1996, we repealed the requirement for actual notice, which was a mistake. If you're like being evicted from your house, you have to get actual notice in order to be removed. You don't have to have actual notice under immigration law. So the premise is incorrect. You know, there are many reasons in the law why you wouldn't be removed. The court would want to grant that. Removing that capacity of the court to administer the law is a mistake in my judgment. I agree with Mr. Correa's amendment, but it goes broader than that. This is simply the wrong approach, but we do need reform because the current system is not working. And I wanted to make that clear because a lot of members don't realize you don't have actual notice. A lot of people never found out about their court hearing, and that's a problem. And Mr. Chairman, I yield back.
Gentlelady yields back. The committee will be in recess until completion of the debate on the Fourth Amendment's not for sale legislation on the floor and the amendments that will be offered to that. And then we'll resume the committee hearing just as quickly after that debate as we can. The committee stands in recess. The question before the committee is the Correa Amendment. Who seeks recognition? Question occurs on the amendment offered by the gentleman from California. Those in favor say aye.
Aye.
Those opposed, no. No. Opinion of the chair, the noes have it.
Oh, yeah.
The ranking member requests to record a vote. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Isa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Ms. Sparts? Mr. Fitzgerald? Mr. Bentz? Mr. Klein? Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson Lee? Mr. Cohen? Mr. Johnson? Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Mr. Neguse? Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes yes. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivy? Mr. Ivy votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Issa, you are not recorded. Mr. Issa votes no. Mr. Massey, you are not recorded. No. Mr. Massey votes no. Mr. Correa, you are not recorded. Mr. Correa votes aye. Ms. Jayapal, you are not recorded. Ms. Jayapal votes aye. Mr. Fitzgerald, you are not recorded. Mr. Fitzgerald votes no. 7, 8. Mr. Bishop votes no.
Have all members voted? Clerk will report.
Mr. Chairman, there are 7 ayes and 9 noes.
7 ayes, 9 noes. The amendment is not agreed to. Is there further discussion on the amendment in the nature of a substitute? Gentlelady from Washington.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment to the
Gentleman from North Dakota reserves a point of order.
amendment to the amendment in the nature of a substitute to H.R. 3591 offered by Ms. Jayapal. Add at the end of the bill the following. Section 3.
Without objection, the amendment will be considered as read. Gentlelady from Washington is recognized for 5 minutes.
Thank you, Mr. Chairman. Once again, we are marking up an overbroad, deeply flawed immigration bill with far-reaching consequences. This bill looks at decades of draconian punishments that haven't worked and says, you know what will fix the situation? Making the punishments even harder. Under current law, an immigrant ordered removed in absentia, meaning that they weren't present in court when the judge handed down the sentence, is barred for 10 years from seeking certain forms of immigration relief. This legislation would expand that 10-year bar to a lifetime ban. And here's the problem. Many of the people who are ordered removed in absentia never received notice of their hearings. The Department of Homeland Security has a long history of issuing improper notices to appear, the charging documents that are supposed to tell immigrants where and when to appear for their immigration court hearing. In the past 6 years, the Supreme Court has twice issued decisions finding that the NTAs issued by the DHS did not follow the notice requirements that were set out in law. If someone doesn't have proper notice of their hearing, how on earth can they be expected to attend? By their own admission, DHS has countless NTAs with no date or time for a hearing. The amendment that I'm offering today would make it clear that the proposed lifetime ban would not apply to people whose initial notice to appear did not comply with the law's requirements. Now, my amendment doesn't fix the whole problem. Even when NTAs meet the statutory requirements, it's often because the document issued by DHS contains false information. For example, they might list the wrong address, or even sometimes a fake address in a major city, meaning that the immigrant will never receive updates about their case. The problems don't stop with DHS either. A 2018 review of the Baltimore Immigration Court by the Department of Justice found that because the court was so understaffed, staff were not entering change of address paperwork into their system. As a result, court notices were sent to the wrong addresses even when immigrants were doing everything right and updating their addresses with the court. A 2022 study painted an even starker picture. A father and his 6-year-old son showed up to the Los Angeles Federal Building with an NTA, thinking that they were supposed to go to an ICE check-in. After showing the NTA to an ICE employee, they were told to wait in the lobby. 7 hours later, they met with an ICE officer who told them that they had been ordered removed in absentia and asked why they didn't go to their hearing, which was in the same building on a different floor. That's right, the father and son showed up on the day of their hearing, but were ordered removed in absentia because an ICE officer could not be bothered to direct them to the right place. By and large, the people coming to this country want to do things the right way. As the ranking member mentioned, a recent study found that 83% of non-detained immigrants attended all their hearings. And that study found that in some years, as many as 20% of all in absentia orders of removal were overturned. And I yield back.
Mr. Nadler.
I yield to the gentlelady from Washington.
Actually, Yeah, actually, we'll go into debate on her amendment, which would begin on the Republican side.
Okay. I withdraw my point of order.
Gentleman withdraws his point of order. Is there any discussion on the amendment? Then I'll claim 5 minutes and simply point out that under current law, it's already a requirement that aliens receive written notice of the time and place of proceeding, the consequences for failure to appear at the hearing, and the requirements to keep their contact information up to date with the immigration court. Moreover, to warrant an order of removal in the alien's absence at court, DHS has the burden of proof to establish by clear, unequivocal, and convincing evidence that the written notice was so provided to the alien. And in addition to that, the alien can appeal the decision based on the presenting evidence that they were not properly advised. So, and these safeguards already apply to the 10-year disqualification. This simply would extend the 10-year disqualification to life based on the fact that they have thumbed their noses at our immigration system. And with that, I will yield back and recognize the gentleman from New York. Gentleman passes. Is there further discussion? Ms. Ross.
Thank you, Mr. Chairman. I just want to speak in support of this amendment. This is basic, common sense due process. And the examples, which were only a few cited by the gentlelady from Washington, happen all over this country every single solitary day. And making the penalty even more stringent demands increased due process protection, and I commend the amendment to the committee.
Would the gentlelady yield?
Sure, I haven't yielded back yet.
Thank you so much. I just wanted to say that if the chairman believes that this is already current law, then there should be no problem with accepting it. As the chairman knows, this issue is being litigated right now in the Supreme Court, and all we are trying to do is make sure that we actually have the ability for basic due process to people who would have shown up to the court had they been properly notified. So I hope we can accept the amendment. I yield back to the gentlelady.
And Mr. Chairman, I yield to the gentleman from Maryland, Mr. Ivey.
Thank you. I want to support this amendment as well. I've been waiting to hear what the factual basis is for the need for the underlying amendment. You know, a lifetime ban as opposed to a 10-year ban, and I haven't heard why 10 years would be insufficient. You know, if there's some, I haven't even heard that there's some number of people who've been, you know, fallen beyond the 10-year ban, and so therefore a life ban would be somehow beneficial or necessary. But beyond that, if Ms. Ross's point is the correct one, I mean, I think if we are going to go more draconian than a 10-year ban, which is very significant, I must say, we should at least have the safeguards that are provided from a due process standpoint by Ms. Jayapal's amendment. And with that, I will yield back to Ms. Ross.
Okay. Thank you, Mr. Chairman. I yield back.
Gentlelady yields back. Is there further discussion?
I'd like to be recognized.
Mr. Bishop.
I yield to the chair.
I thank you very much for yielding, Mr. Bishop. I simply want to point out that the Democrats' arguments contradict their own administration. It's getting rather amusing to see the contortions that they're going through on this. In an oral argument in January, the Biden administration emphasized that without receiving the time and date of the court hearing, an alien would be able to challenge an in absentia order under the regulations and the statute that currently exists. The Biden administration highlighted in particular, quote, in more than 500,000 in absentia removals, it has never happened, unquote. The DHS was proceeded with an in absentia removal order for an alien who's not provided the required information. Not once in 500,000 in absentia removals. In fact, even the Biden administration argued before the Supreme Court that a notice of hearing is sufficient to put aliens on notice of their immigration court hearings and then serve as the basis for an in absentia removal order when they fail to appear. And I yield back. Further discussion? Yes, Ms. Escobar.
Thank you, Mr. Chairman. I rise to support Ms. Jayapal's amendment. Thank you, Ms. Jayapal, for offering this important amendment. And I would like to echo the question asked by Mr. Ivy. I too am very interested in hearing the rationale and the reasoning behind going from a 10-year bar to a lifetime bar. That has yet to really, I mean, is there some data? Is there some logic? Is there something that anyone on the other side would like to share with us as to why this significant jump from 10 years to lifetime would be warranted? And secondly, I'd like to say, you know, this committee recently came together as we debated the FISA reauthorization, and we talked a lot about due process, and we did it in a bipartisan way, which is unfortunately unusual. I wish it were far more common. And Ms. Jayapal's amendment seems like a very simple request in order to strengthen and guarantee due process. So I'm not quite sure why there would be any objection to that, especially given some of the debates that we've recently had and some of the areas of agreement that we've recently had. So those are my two questions that I hope someone answers. And with that, I yield back.
Gentlelady yields back. Is there further discussion? Seeing none, the question is on the adoption of the amendment in the nature of substitute by the gentlelady from Washington. The amendment offered by the gentlelady from Washington. The secretary call the roll. Oh, I'm sorry. We need to do a voice vote first. Those in favor of the amendment say aye. Aye. Those opposed say no.
No.
The noes have it.
Roll call.
Roll call is requested. Secretary call the roll.
Mr. Jordan. Mr. Jordan votes no. Mr. Issa. Mr. Gates. Mr. Biggs. Mr. McClintock. Mr. McClintock votes no. Mr. Tiffany. Mr. Massey. Mr. Roy. Mr. Bishop. Mr. Bishop votes no. Ms. Spartz. Mr. Fitzgerald. Mr. Fitzgerald votes no. Mr. Bentz. Mr. Klein. Mr. Klein votes no. Mr. Armstrong. Mr. Armstrong votes no. Mr. Gooden. Mr. Van Drew. Mr. Nels. Mr. Moore. Mr. Moore votes no. Mr. Kiley. Mr. Kiley votes no. Ms. Hageman. Ms. Hageman votes no. Mr. Moran. Ms. Lee. Ms. Lee votes no. Mr. Hunt. Mr. Fry. Mr. Nadler. Mr. Nadler votes aye. Ms. Lofgren. Ms. Jackson-Lee. Mr. Cohen. Mr. Johnson. Mr. Schiff. Mr. Swalwell. Mr. Liu. Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Mr. Correa votes aye. Ms. Scanlon. Mr. Neguse. Ms. McBath. Ms. Dean. Ms. Escobar. Ms. Escobar votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Bush. Mr. Ivy. Mr. Ivy votes aye. Ms. Ballant. Ms. Ballant votes aye.
Clerk will report.
Mr. Chairman, there are 7 ayes and 10 noes.
7 ayes and 10 noes. The amendment is not agreed to. Is there further discussion on the amendment in the nature of a substitute? Ms. Escobar.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will report.
Amendment to the amendment in the nature of a substitute to H.R. 3591 offered by Ms. Escobar. Add at the end of the
Reserve a
bill
point
the
of order.
following.
Point of order is reserved. Without objection, the amendment be considered read. Chair recognizes Ms. Escobar for 5 minutes.
Thank you, Mr. Chairman. This amendment is very simple. While this bill is called the Asylum Accountability Act, the bill itself has a much broader impact, barring lawful permanent residents, also known as LPRs or green card holders, and others here on temporary visas from important forms of relief. This amendment would exempt LPRs from this overly punitive bill. Under current law, if a lawful permanent resident is placed into removal proceedings, they can seek what is called cancellation of removal. An immigration judge can then, in their discretion, cancel the removal and allow them to stay in the country as an LPR. Currently, if an LPR is ordered removed in absentia, they are barred from seeking this relief for 10 years. As written, this bill would make that bar permanent. To be eligible for cancellation of a removal, an individual cannot be convicted of a serious crime and must have been an LPR for at least 5 years. There is absolutely no reason that Congress should be cutting off avenues for relief for people who have lawful status and condemning their U.S. citizen spouse and/or child to such an unnecessary hardship. If anything, we should be finding ways to expand legal pathways so people can come here lawfully. Let's be clear about the impact of this bill. Studies show that immigrants want to attend their proceedings and see out their cases. Overall, 83% of migrants do show up to their court hearings. In fact, 96% of individuals who had an attorney to help provide guidance through the complicated immigration court process showed up to all of their immigration court hearings. When immigrants do miss court, oftentimes there are good reasons. One of the main reasons people miss their immigration court hearings is because they never received adequate notice of the hearing to begin with. In 2018, the federal government admitted in court that almost every single charging document they had issued to a migrant over the past few years did not have a date or time for them to show up in court. So a green card holder who never got notice for his hearing gets ordered removed, and you want to bar that person from a key form of relief? Are these the kind of people that the majority is meaning to capture with this bill? They have nothing to do with asylum, and this amendment has nothing to do with asylum seekers. If the majority is serious when they say they support lawful immigration, there should be no problem with this amendment. Thank you, Mr. Chairman. I yield back.
Point of order withdrawn.
Gentleman withdraws a point of order. Is there any discussion on the amendment? I'll claim time simply to point out that the LPRs right now, under existing law, are applied this 10-year ban. This amendment exempts LPRs who don't show up for their court hearing from any sanction on future immigration reviews. Again, the LPRs already, under current law, are subject to that 10-year ban. This amendment would remove them from that 10-year ban, would remove them from any ban. And consider what happens to citizens who don't show up for their court hearings. If someone fails to appear at a criminal or civil court proceeding in a non-immigration context, they could face prison time, see the permanent dismissal of a case, or even be charged with a felony. So this introduces not only a giant step backward from current law, it also introduces and perpetuates a double standard between illegal immigrants and people who have obeyed all of our laws to come here and be citizens. With that, I will yield back and recognize the gentleman from California for 5 minutes.
Mr. Chairman, just a question. You're talking about citizen charged with a felony versus a lifetime ban. Are we comparing both as equal?
You seem to be applying a double standard. If the gentleman is yielding, you appear to be applying a double standard to this law.
We're not applying a double standard. We're talking immigration law versus criminal law versus civil law. Here we're talking about the bill here, subject matter, talking about lifetime bans for not showing up in situations where the facts would say those individuals did not have the knowledge that they were scheduled to show up at an appointment somewhere. It just, where's the process? Where's the fairness? Just doesn't equate, sir, when you're trying to compare both. To a citizen who's scheduled to show up for a hearing, knowing when to show up, time, date, and place, versus a situation where there is no knowledge of having to comply with such an order.
Would the gentleman yield?
Yes.
Thank you, Mr. Correa. And if the chairman believes that current law is good law, we have an amendment to go back to the 10 years. Happy to present that.
Well, that would obviate the whole point of the bill, wouldn't it? And simply restate current law, wouldn't it?
Well,
nice try.
If you are a
Nice try. No,
champion
thank
of
you.
current law, happy to.
I'm saying the current law
support
has
that.
plenty of protections that are already there.
Well, we disagree.
Then
And I
why
yield
would-
back to Mr. Correa.
Would the gentleman yield?
Of course, yes.
I just want to observe that there's discussions like this that make me thank God for the United States Senate to know that all of these bills are going nowhere. I yield back.
Anybody else?
Well, I think the American people are going to have something to say about that
Mr.
in a
Ivey?
few months. Is there
Thank you. I
further
yield, Mike.
Gentleman yields back. Is there further discussion on the amendment? Seeing none, the question is on the adoption of the amendment by Ms. Escobar. Those in favor say aye. Aye. Those opposed say no. No. The noes appear to have it. Roll call is requested. Secretary, call the roll.
Mr. Jordan? Mr. Jordan votes no. Mr. Issa? Mr. Gates? Mr. Biggs? Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes no. Ms. Sparks? Mr. Fitzgerald? Mr. Benz? Mr. Benz votes no. Mr. Klein? Mr. Klein votes no. Mr. Armstrong? Mr. Armstrong votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Mr. Moran? Ms. Lee? Ms. Lee votes no. Mr. Hunt? Mr. Fry? Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Jackson-Lee? Ms. Jackson-Lee votes aye. Mr. Cohen? Mr. Johnson? Mr. Johnson votes aye. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Mr. Correa votes aye. Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Mr. Neguse votes aye. Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes aye. Ms. Ross? Ms. Ross votes aye. Ms. Bush? Mr. Ivey?
Aye.
Mr. Ivey votes aye. Ms. Ballant? Ms. Hageman, you are not recorded. No. Ms. Hageman votes no. Mr. Fitzgerald votes no. Mr. Issa, you are not recorded. Mr. Issa votes no.
All members voted? Clerk will report.
Mr. Chairman, there are 10 ayes and 12 noes.
10 ayes, 12 noes. The amendment is not agreed to. Is there further discussion on the amendment in the nature of a substitute? Seeing none, the question is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. Those in favor say aye. Aye. Those opposed say no.
No.
In the opinion of the chair, the ayes have it. The amendment in the nature of substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. Those in favor say aye. Aye. Those opposed say no.
No.
The ayes have it, and the bill is ordered to be...
Roll call, please.
Roll call is requested. Secretary, call the roll.
Mr. Jordan? Mr. Jordan votes yes. Mr. Issa? Mr. Issa votes yes. Mr. Gates? Mr. Biggs? Mr. McClintock?
Aye.
Mr. McClintock votes aye. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Bishop? Mr. Bishop votes yes. Ms. Sparts? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Bentz? Mr. Klein? Mr. Klein votes aye. Mr. Armstrong? Mr. Armstrong votes yes. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Mr. Kiley votes aye. Ms. Hageman? Ms. Hageman votes yes. Mr. Moran? Ms. Lee? Ms. Lee votes yes. Mr. Hunt? Mr. Fry? Mr. Nadler?
No.
Mr. Nadler votes no. Ms. Lofgren? Ms. Jackson Lee? Ms. Jackson Lee votes no. Mr. Cohen? Mr. Johnson? Mr. Johnson votes no. Mr. Schiff? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes no. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Mr. Neguse votes no. Ms. McBath? Ms. Dean? Ms. Escobar? Ms. Escobar votes no. Ms. Ross? Ms. Ross votes no. Ms. Bush? Mr. Ivy?
No.
Mr. Ivy votes no. Ms. Ballant? Mr. Benz? Mr. Benz votes yes.
So you finish it, I'll let you finish your bill, then we'll go, or Mrs. Rouser? You finish the bill, we'll let-
Ms. Ballant, you're not recorded. Ms. Ballant votes no.
A report's getting some play.
Mr. Correa, you are not recorded. Mr. Correa votes no. Mr. Gooden votes aye.
Have all members voted? Clerk will report.
Mr. Chairman, there are 13 ayes and 11 noes.
13 ayes and 11 noes. The ayes have it. The bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.
Pursuant to notice, I call up H.R. 3269, the Law Enforcement Innovate to De-Escalate Act. It's a mouthful there. For purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 32.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from Wisconsin, Mr. Fitzgerald, for an opening statement.
I want to thank the chairman. Thank you to my colleagues, specifically Mr. Stanton, who helped just a great deal in not only the background but helped to work with other members as well for introducing this bill. I'm proud to co-lead H.R. 3269, the Law Enforcement Innovate to De-Escalate Act, which would revise and modernize the Gun Control Act of 1968, or the GCA as it's referred to exempt certain less than lethal devices from the definition of a firearm. The Gun Control Act was enacted to assist law enforcement in their fight against violent crime. Along with imposing stricter licensing and regulation on the firearms industry, the GCA also established a new definition of a firearm, which, according to the bill, includes, quote, any weapon, including a starter gun, which will or is designed to or may readily be converted to expel a projectile by the action of an explosive. While that definition has been suitable to the firearms industry for the last 55 years, modern advancements in less than lethal technologies, such as tasers, have created a need for Congress to take a second look at the definition to ensure the Gun Control Act, as written, does not stifle innovation. It's also important in promoting transparency during law enforcement encounters. For example, if a less than lethal weapon, such as a taser, uses an explosive propellant to fire its projectile, which in the case of a taser is its barbs, it would be classified as a firearm, despite its low probability of serious injury or death. And because that weapon is considered a firearm, it's used during a law enforcement encounter, that use may be considered deadly force in 43 states across this country. This includes my own state of Wisconsin, which includes it in its definition of deadly force, the discharge of a firearm. It is unintended consequences of a law passed long before advancements in less than lethal technologies that has led to fewer law enforcement agencies adopting more innovative tools due to their same classifications and restrictions as other firearms. Law enforcement agencies agree and have been asking for this, and so I would ask that the following letters of support be included in the record.
Without objection.
A letter of support from the Major City Chiefs Association dated April 19, 2023. A letter of support from Major County Sheriff's Association dated April 22nd, 2023. A letter of support from the National Fraternal Order of Police dated June 16th, 2023. A letter of support from the International Union of Police Associations from April 15th of 2024. And a letter of support from the Milwaukee Police Association dated April 15th of this year.
Without objection.
The letters all agree that this change not only encourages more innovation within the less than lethal weapon space, but also promotes de-escalation during law enforcement encounters, which is something even President Biden has called for in his May 2022 executive order. This change, I believe, is in the best interest of law enforcement officers. I would urge its passing, and I yield the balance of my time.
Gentleman yields back. The chair now recognizes the ranking member for an opening statement.
Mr. Chairman, for decades, law enforcement has sought out tools that would enable them to respond to a range of situations as they work to keep our communities safe. Among the tools available is a growing array of weapons that are designed to be less lethal than traditional firearms, providing officers with options to de-escalate a situation, stop a suspect, or prevent immediate harm without having to resort to a sidearm. Democrats have consistently supported legislation that gives law enforcement the tools and training to make our communities safer, including legislation that would promote the use of less than lethal weapons in place of lethal weapons. But this bill would take us in the opposite direction. Despite its title, this bill has nothing to do with law enforcement. In fact, the title of the bill is the only place that the words law enforcement are found. What this legislation does is rewrite the definition of firearm throughout the entire criminal code to exclude certain less lethal but still highly dangerous weapons. This would apply not only to law enforcement but to everyone, including those who are not legally allowed to possess firearms. The bill creates a new loophole that will put dangerous weapons into the hands of domestic abusers, convicted felons, and others prohibited from having a firearm, providing them access to these weapons without a background check. Under this loophole, the regulations that make guns traceable will also not apply to these less lethal weapons, so they will be untraceable when they are used in crimes. The bill makes all of us, including law enforcement, less safe. Supporters of the bill argue that it is needed to bring the Gun Control Act of 1968 in line with modern technology and ensure that law enforcement can use these less lethal weapons. While it is true that technology is always advancing, many of these weapons have been around in essentially the same form for decades, and many of them have consistently been found to meet the definition of a firearm. The classification of some less lethal weapons as firearms did not prevent many law enforcement agencies from adopting them as they were developed and refined, and less than lethal weapons continue to be used by many law enforcement agencies today. Supporters also argue that change is needed because the classification of these weapons as firearms in federal law may result in the use of the weapon being considered deadly force, even though the device is designed to be less than lethal. But states are more than capable of updating their laws to account for these technologies, and many do have laws specific to less lethal weapons. Contrary to the assertions made by supporters of the bill, federal courts have found the use of these devices to be a form of, quote, intermediate force, while recognizing that they could still cause serious injury and, quote, present a significant intrusion upon an individual's liberty interests. There is no indication that federal or state law, including judicial precedents, are out of step with the design and use of these weapons, much less that such a mismatch has prevented law enforcement adoption of these tools. To the extent that a state or court may choose to regard the use of these weapons as deadly force, it might be because these weapons can cause serious injuries and even kill. Lethal in Disguise 2, a joint report of the International Network of Civil Liberties Organizations, Physicians for Human Rights, and the Omega Research Foundation, found that weapons that are supposed to be less lethal have caused permanent blindness, brain damage, internal bleeding, eye injuries, burns, other severe injuries, and numerous deaths, especially when used inappropriately. Unfortunately, many people experience the inappropriate use of these less lethal weapons firsthand during the protests in response to the murder of George Floyd. During these protests, numerous demonstrators, bystanders, and journalists suffered severe injuries after being hit with projectiles that are designed to be less lethal. At least 60 people sustained serious head injuries, and at least 7 people lost an eye. One woman was put in a medically induced coma in an effort to help her recover from severe injuries. Clearly, these weapons are in fact dangerous and even deadly. They will continue to be, whether or not they are classified as firearms. Many law enforcement agencies have policies that recognize the potential harm of less lethal weapons and restrict their use to immediate threats of violence or physical harm, require reporting of the use of less than lethal weapons, and promptly review uses of these weapons to prevent abuse, just as they do for traditional firearms. With appropriate policies, departments can and already do use less lethal weapons to improve community safety and avoid resorting to lethal force. Given that law enforcement already does have access to less lethal weapons, there simply is no need for legislation that creates a dangerous loophole that would make all of us less safe. I urge members to oppose this legislation, and I yield back the balance of my time.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes...
Chairman, Mr. Chairman.
We're going to do the ANS, and I'll get to you. The chair now recognizes the gentleman from Wisconsin for the purpose of offering an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report.
Amendment in the nature
Without
of...
objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair now recognizes the gentleman from Wisconsin to explain his amendment.
Mr. Chairman, this amendment simply adds the year 2024 to the title of the bill. It's not intended in any way to alter the important purpose of the bill. I urge adoption of my amendment, and I yield back.
Gentleman yields back. The gentlelady from the great state of Texas is recognized.
I thank the gentleman very much, and I rise to, and I sit to strike the last word, Mr. Chairman.
The gentlelady is recognized.
It is critical that law enforcement officers have the tools they need to do their jobs. Every time a law enforcement officer can contain a dangerous situation for himself or otherwise, or prevent a shooting without using a lethal force, is a time that officer has potentially saved a life, his or someone else's. As a strong advocate for de-escalation, I believe that there could be opportunities for us to further support the use of less lethal weapons in place of lethal force. If we were operating under regular order, we could have had a hearing with law enforcement, ATF, civil rights leaders, and others about how less lethal weapons could be used to reduce officer-involved shootings and make all of us safer. But instead, we are again proceeding to mark up without a hearing on a complex issue with unresolved technical questions. The dangers of this bill were identified nearly 2 years ago when the Department of Justice reviewed a prior version of this legislation. That review included input from numerous experts, including prosecutors, law enforcement, and firearm experts. Each of these experts raised significant concerns about this legislation, which have not been addressed in the version before us today. They warned us that this bill will put dangerous weapons in the hands of prohibited purchasers, domestic abusers, convicted felons, and those seeking to target law enforcement. This bill also would pave the way for these weapons to be used in schools, hospitals, and mental health institutions where traditional firearms are prohibited or inappropriate. An SEC filing from one manufacturer shows that it hopes to profit from getting the device into these settings. Unfortunately, we know too well that happens when dangerous devices are present in our schools and when students, especially students of color, are viewed as needing to be controlled rather than respected, even when those devices are deemed less than lethal. In 2021, Mr. Chairman, students of Little Elm High School in Dallas, Texas, organized a walkout. Police responded to the walkout, and videos from the day before show that police using pepper spray and a laser on a black teenager. Education advocates have argued that when used in high schools or used in schools, then devices could actually increase the degree of force used against students of color, because they could be used instead of those dangerous physical restraints. For these less lethal weapons to be effective, they have to be used as an alternative to lethal force, not as a substitute for safe alternatives like de-escalation or handcuffs. Undoubtedly, there are times when law enforcement officers have used these lethal weapons responsibly and effectively, containing or controlling a situation without resorting to firing a gun. Unfortunately, this legislation would not advance that goal and would instead create a loophole that will endanger all of us. I, like the multitude of experts and practitioners who chose to weigh in, must oppose this bill and urge my colleagues to do the same. And I thank the chairman and yield back at this time. We hope that we have further opportunity to look at these issues and be well-informed to have a safe community, Mr. Chairman, for our students and law enforcement and others. With that, I yield back.
Gentlelady yields back. The gentlelady from Wyoming is recognized.
Mr. Chairman, I seek to strike the last word.
Gentlelady is recognized.
Thank you, Mr. Chairman. I strongly support the Law Enforcement Innovate to De-Escalate Act. legislation which I am proud to co-sponsor. This bipartisan legislation will make much-needed updates to federal gun laws, updates which ensure that Congress, not the ATF, is determining the intent with respect to federal firearms laws and making important less-than-lethal threat mitigation tools available for all law enforcement officers. Currently, the ATF inhibits law enforcement access to certain less-than-lethal devices, such as tasers, by classifying many of these devices under federal firearms law, such as the Gun Control Act. Tasers are classified this way even though this technology did not exist when Congress passed the Gun Control Act, and even though Congress never intended to regulate this technology as a firearm. There are a variety of less-than-lethal tasers being developed which will protect police officers and end violent encounters without the risk of death or serious bodily injury. However, law enforcement across the country struggles to obtain access to this life-saving de-escalation technology because of the costs, compliance challenges, and delays which stem from these tasers being classified under federal gun laws. As the lone representative for Wyoming, I have seen the challenges that our smaller law enforcement agencies can have complying with federal regulations to access equipment and funds. As the chair of the Subcommittee on Indian and Insular Affairs, I have also heard concern from tribal law enforcement entities about how the ATF classification of these less-than-lethal technologies under federal gun laws creates numerous jurisdictional questions to prevent tribal law enforcement officers from accessing these threat mitigation tools. This is a good, common-sense bill, and I commend Mr. Stanton and Mr. Fitzgerald for their bipartisan work in developing this legislation, which will go a long way to protect police officers and help safeguard our communities. I urge my colleagues to vote in favor of this bill, and with that, I yield back.
Lady yield.
Gentlelady yield to the gentleman from North Dakota. Ms. Hageman?
Yes.
Gentleman recognized.
Thank you. I couldn't agree more with the gentlelady from Wyoming. You can be in places in North Dakota where you're measuring backup in hours and not minutes. And the reality is I see this as a protection for both the defendant or the offender and the law enforcement officer. This is a fairly binary choice. You decide whether the use of force is appropriate, and you use it. You don't get into how big the offender is, how big the law enforcement officer is, what the other accepting conditions are, because there's two sides to this. One, we want to make sure that officers are only using these when appropriate. But we also want to protect officers not only from being harmed, but also from being sued.
Yep.
And this takes a lot of that equation out of here. And then, I mean, we classify them however you want, but they're not a firearm. And that's the functional thing. And there are enforcement agents that their insurance won't cover them. The new technology shoots them farther than their insurance will cover them. But when you live in places like me and the Congresswoman from Wyoming are, you need to recognize that your law enforcement agents don't particularly have the access to backup in a lot of different times. And sometimes de-escalation works. The single best way to de-escalate a situation is to deal with it very, very quickly. And so it takes discretion, it takes abuse, choking, all of the different issues. When you decide you have to utilize force and you decide this is the more appropriate way to do it, then that is the set of facts that exist, and that is the set of facts that both sides can argue at any point in time in the future. And I think this is good legislation, and it allows law enforcement agents to utilize the technology available to them to keep their communities safe and keep themselves safe, both physically and legally. And with that, I yield back.
Just very quickly, one other point. The ATF is notorious for attempting to classify things that are as firearms, which are not firearms, and misclassify things in order to control them and limit our access to them. I think that this is another example of that, these less than lethal force mechanisms, and I support this bill, and with that, I
Will the
yield back.
gentlelady yield? Just for,
Yes, I will.
well, and the ATF is great at changing the definition of things and suddenly making Americans felons. We saw that with the pistol brace issue. So the point is well taken, and I think the comments from the gentleman from North Dakota are well taken as well. I yield back.
I yield back.
Gentlelady yields back. We'll go to the gentlelady from Pennsylvania, and then the gentleman from Texas.
Thank you, Mr. Chair. I move to strike the last word.
Gentlelady is recognized.
Of course, I support ensuring that our law enforcement officers have appropriate tools and training to make our communities safer. And that includes investing in successful de-escalation strategies and tools. But I'm concerned that this bill, despite its alleged intent, would actually create a new loophole in our background check system that would put dangerous weapons into the hands of those we all know should not have them. And ultimately, in doing so, it would make our communities and law enforcement less safe. Despite the bill's title, its application is not limited to use by law enforcement personnel. It would redefine the weapons in question so they no longer are firearms and therefore are not subject to firearms or other regulations, regardless of the identity of the user or purchaser. So people who could not obtain a firearm will be able to obtain these weapons, which actually are serious weapons. That's why we've heard serious concerns about this bill's implications from ATF, from the Department of Justice's Criminal Division, and the Executive Office for the United States Attorneys, who of course are the federal prosecutors. So this includes the harm, their concerns include the harm this could cause to law enforcement security personnel and the public. Should people legally prohibited from owning firearms be given unchecked access to dangerous explosive projectile weapons? So I find these concerns troubling, and for that reason, I'm unable to support the bill as is. And I associate myself with Representative Jackson Lee's remarks about the fact that this is a bill that requires further work in order to address those concerns. As drafted, the bill appears to be a bill designed to boost sales for the manufacturers of these devices, rather than an actual public safety measure. So I find these concerns troubling. For that reason, I can't support the bill as is, and I yield back.
Gentlelady yields back. Gentleman from Texas is recognized.
Thank you, sir. Law enforcement for 30 years, a sheriff, Fort Bend County, large county, all my deputies had 826 employees. We had tasers. And thank goodness they had the tasers, because I think the taser saves a lot of lives, quite honestly, had a lot of lives saved. When I first started in law enforcement, what we had back then, we had this little oleo caps and this little OC spray you'd try to spray, right? Individuals that would be on high on some type of a drug or narcotic, they'd just kind of lick it off their face. You would have to go to something else. So we had an aspeton. You remember this aspeton, a little thing here? You'd have to throw it out there, flick it out there. I used the aspeton quite a bit, but I noticed that was somewhat not very effective at times, especially when you're dealing with big, big, burly fellas. And then when they come out with this taser, what a great thing for law enforcement, using that taser. Matter of fact, if you just press the button on that taser and you hear that little, if you take the prongs off and you want to take it and put it on a gentleman's neck or on the back or something, and you just press that little, it has that little shocking noise. Let me tell you, people are going to comply. It's kind of like when you rack a shotgun. Somebody coming into your house, you rack that shotgun, you don't even have to shoot the damn thing. They're going to be out of there. They're getting out of there. They know what that noise means. But numerous times over and over in my law enforcement career, that taser was deployed in situations, quite honestly, when I felt and a deputy of mine would have had the ability to use deadly force. They used the taser because if you look at the use of force continuum, it's officers present. You think, well, an officer's there, he's standing there. If you can't get compliance with that, then you go to the verbal commands, right? If verbal commands, then you go to this kind of soft arm approach. You go up there and you grab him by the arm and you try to move him by moving his arms, this and that. If that's not working and he gets combative, you release. You release. And then you go to your taser. You go to your taser, a less than lethal weapon. And when you pointed that taser at somebody, that guy is going to know, hey, I know what that is. Everybody knows what it is because it's yellow for the most part. And if the taser didn't work, then you go to the next to highest level, lethal force. The idea that this committee and people across this country would not support taking tasers and using them, we shouldn't just have tasers on every law enforcement officer in this country. We should have tasers on drones. Take the technology and move it so you don't have to have an officer even holding that damn taser. Put it on a drone. They will tell you, folks, they will tell you in the training on use of force, If a gentleman is 21 feet away from you, 21 feet, and he's got a knife, and you got your gun and you haven't cleared leather, he's gonna have that knife inside you before you can clear that leather and point that gun and shoot him and stop the threat. I'm telling you, if this committee or anybody in America thinks that deploying tasers in some form or fashion is deadly force, could people have a heart attack as a result? I guess they could. But I am telling you right now, tasers are less than lethal. It saves lives every day, and law enforcement officers across the country are using it. Why don't you go ask them? Go ask them. Instead of us thinking we're so smart in this room, why don't you go ask the officers who are out there and with their tasers and say, do tasers save lives? It saves lives every day. I can attest to that because it saved a lot of lives in our county. It saved a lot of our lives of our deputies. So my point is this. We need to expand the use of tasers. We need to start putting them on drones as well. Anyway, I yield back.
Gentleman yields back. Gentleman from Georgia is recognized.
Thank you, Mr. Chairman. This bill has absolutely nothing to do with law enforcement and everything to do with making the gun lobby and gun manufacturers happy. And so that's why I'm going to propose an amendment that renames this bill, which is now called the Law Enforcement Innovate to De-Escalate Act. I want to rename it to Make the Gun Lobby and Gun Manufacturers Happy Act. Mr. Chairman, Democrats support legislation that gives law enforcement the tools and training to make our communities safer, including legislation that would promote the use of less than lethal weapons, but this bill does not make us safer. This bill makes all of us, including law enforcement, less safe. It creates a new loophole to the background check system that will put dangerous weapons into the hands of domestic abusers, convicted felons, and others prohibited from having a firearm. Again, this bill has nothing to do with law enforcement. It makes law enforcement harder. The only place it even says law enforcement is in the title. Law enforcement officers are already exempt from the Gun Control Act and can obtain any kind of firearm, including those that are designed to be less lethal. But I tell you, I shudder at the thought of a taser being deployed from a drone, and I shudder to think of the day when we start using drones domestically to fire projectiles at our fellow citizens. That's kind of scary. Nearly 2 years ago, the Department of Justice examined this bill, and they sought input from our federal prosecutors, law enforcement, and firearms experts. All of the offices that they consulted had significant concerns about the bill, which still haven't been addressed 2 years later. The Executive Office for the United States Attorneys said, quote, "We oppose this proposal. Contrary to what the title of this proposed bill suggests, it would have a broader application beyond law enforcement. The less lethal devices could still harm others, and it's unnecessary to create this kind of exception. Further, the proposed definition of a less lethal device would be unworkable in the field," end quote. ATF explained that the bill would, quote, "allow non-lethal weapons to be exempt from all Gun Control Act requirements when being transferred to non-law enforcement personnel, including licensing, marking, record keeping, and background checks," meaning persons prohibited from possessing a firearm would be legally allowed to possess explosive projectile weapons. These weapons could be used against law enforcement, security personnel, or the public, creating an increased risk of harm to public safety. They also would not be traceable if used in a crime, end quote. And last but not least, the criminal division succinctly stated, quote, "This legislation would weaken our efforts to keep weapons out of the hands of dangerous persons. The criminal division opposes the legislation in its current form, end quote. So this bill also has no definition of projectile. So the loophole it creates would allow for weapons to shoot any ammunition, including bullets, as well as weapons that could easily be converted to a standard gun. Can you imagine a drone out there with a projectile on it, a .44 Magnum projectile on it being fired from a drone? I can't imagine that. At base, this bill appears to be a boondoggle for manufacturers of less than lethal weapons, as one manufacturer admitted in a recent SEC filing. Proliferation of these weapons without background checks makes us all less safe, and with that, I ask my colleagues to vote no on this legislation, and I yield back.
Gentleman yields back. I'm going to strike the last word and recognize myself for 5 minutes. I just want to talk about a couple of things that have already been said. Congressman Stanton and I carefully crafted the legislation to ensure that there is no exploitable loopholes, which I think some of the members who have been critical, you've got old information. And, you know, you should talk to your colleague, Congressman Stanton, about kind of what we did and where we went. It's accomplished by employing, there's a two-pronged test for the ATF to consider when determining whether a product submitted for classification is truly a less than lethal projectile device. In the first test, an objective test, the ATF would evaluate whether the product submitted for classification is designed or intended to expel a projectile at a velocity exceeding 500 feet per second. Because the technology is changing. 2 years ago, you're talking about 2 years ago? The technology has advanced significantly since then. And the second subjective test would give the ATF the ability to determine whether the product is designed or intended to be used in a manner that is not likely to cause death or serious bodily injury. And this is what law enforcement has been requesting. This prong ensures that even in a device that fires a projectile at 499 feet or lower is created, ATF can still step in and classify the device as a firearm. So we were very careful. I mean, Congressman Stanton and I looked through this and said, what are the things we could certainly work on to make this comply with the Gun Control Act? So the other thing I just wanted to talk about is the changing of the firearm classification. So the ATF, they have a very robust and thorough classification process to determine kind of whether a product is a firearm under the Gun Control Act or National Firearms Act. Because there's other things that law enforcement uses that fall into a different category. And the request for a classification determination, they're required to be submitted to ATF under the regular penalties and must include all the relevant parts and accessories that are part of that. So under the text on H.R. 3269, any product submitted to ATF for classification will be scrutinized under ATF's existing classification process. ATF retains its full authority to regulate a device as a firearm unless both the objective and subjective prongs of the H.R. 3269 test are fully satisfied. So this bill does not disturb ATF's right to rescind a prior classification determination or request that a device be reevaluated under newly implemented regulations or if there's any significant changes to how the product is used by the public. So I once again, I mean, I know that, there may be some concerns and I was under the impression that Congressman Stanton had talked to many of the members who may have had concerns about, where we were in previous bills. But I still think the bill that is before us today makes a lot of sense. It's going to help law enforcement. They're asking for it. I certainly think that H.R. 3269, if you look at it, this is state-of-the-art, less than lethal technology that's currently available. And that's why law enforcement is asking for it. There are situations in some states which I mentioned earlier, where, you know, without this bill, it still ties the hands of law enforcement when it comes to liability. So once again, I would urge people to support the bill. I think it makes a lot of sense, and I think Congressman Stanton has done a good job in being a good author that's been very diligent in the way this is worded. So,
Would the gentleman?
I yield back. Anybody else seek recognition on the topic?
Well,
Someone would need to.
Do we have someone on this side seeking recognition
Gen-
of members?
Yeah, the gentlelady from Texas
What?
is out of time.
No.
Is there?
Gentleman from Maryland.
Gentleman from Maryland?
Lady from Texas.
Gentleman yields to
Gentlelady.
the gentlelady from Texas for 5 minutes.
The gentleman from Mr. Stanton, I wanted to be known because he was a member of this committee. The gentleman from Arizona is a very fine member, and the proponent, who is now chairing the committee in place of Mr. Jordan, who's coming back in, is a very fine member as well. So we have two very fine members. I want you all to have a visual. Certainly, we know that drones have been used to bring down, to de-escalate. Yes, as I reintroduce the George Floyd Justice and Policing Act today, our framework will be the de-escalation and the saving of lives and the making of America. Let me take those words and just say reordering and allowing police officers to safely engage in the importance of public safety. And that would mean that they would have the tools, the safe tools of reducing, of de-escalation, of reducing the danger, which is the argument that proponents of this legislation, Mr. Isley, make as their core framework, reducing dangers and allowing law enforcement to be safe, and as well to be allowing those of us who propose to be safe in our respective communities to be safe. My posture is to de-escalate and to make our communities safe, our families safe, our children safe. And I hold those to be enormously important responsibilities to ensure that these are, if you will, keenly important for us to address. Mr. Johnson has made excellent points, both to his audience, his constituents, very thoughtful points that he has made. I would raise the question, as he has raised the question, of the idea of having these weapons held to your head. Proposing these weapons would be held to your head. The company wants to sell high-tech lasso weapons to schools and hospitals. The high-tech police lasso is being condemned by mental health experts. Those would be the very recipients of the contracts, is to ensure that the communities that would need these high-tech lasso weapons to schools and hospitals would feel good. They would feel prepared. They'd feel ready to use these. And yet, I would put a caution sign, a red light. Don't move so fast to utilize these weapons. Don't move. The clock is ticking down, 107, 105, 10. Don't go so quickly to do that because we have in our hands a particular weapon that if it was held to your head, Mr. Johnson used a .44 caliber. and any other caliber and held to your head. And someone might be saying, well, you couldn't get that close. Well, yes, you can. And I would think that you would feel endangered, frightened, worried about your life, in jeopardy of your life. And that's what the job of this committee is, to be able to confront those violent weapons, both presently and forthrightly, and to protect you, the member who is on this committee, to protect members who are on this committee, and to protect others who the police is trying to de-escalate against this kind of violence. I would make the point that this does not help you. If the police has gotten close enough, this does not help you. Let me conclude by saying, let me reserve and conclude because I see my time is up.
Does anyone else seek recognition?
Just a moment. I just said, I see my time is up, and I don't know if any other members seek that. If they do, I'd like to be able to conclude if they do not at this time. So a member does seek time.
Recognize the gentlelady from Vermont.
I yield from the gentlelady from Texas.
My point that I was trying to make is that even ATF has had questions about whether or not you're safer with this particular product. And that's what guns are. They're products that kill. And I'm simply here trying to create an atmosphere that my colleague created that clearly says that the weapon, the device is not safer at this point. And we have letters that we will submit later on that indicate that. And I know we're up a rough side of the mountain. For my colleagues will probably have the votes. But I would say to you, and I thank the gentlelady from Vermont, I say to you that we are not safer, that we're in an uncanny position of putting forth a weapon that may make us less safe. So knowing that is the case, I want to at least put into the record the company wants to sell high-tech lasso weapons to schools and hospitals.
Without objection.
Unanimous consent. And then this high-tech police lasso is being condemned by mental health experts as unanimous consent.
Without objection.
So the point that we're making, those of us who oppose it, is that we're making a point that it is not a safe device. It's not a safer device. We are looking for devices that will help us effectively use the law enforcement tool, a gun, and to make it, if it's possible, to make it safer. We're not running away from the idea of making it safer, but we are concerned that this does not do so, and these devices do not at this time. Just to give these words, nearly 2 years ago, the Department of Justice examined this bill. They sought input from our federal prosecutors, law enforcement, and firearm experts. And all of the officers they consulted had significant concerns about the bill, which still haven't been addressed 2 years later. We must be able to find common ground. The executive officer for the Office for the United States Attorney said, quote, "We oppose this proposal, contrary to what the title of this proposed bill suggests. It would have a broader application beyond law enforcement. The less lethal devices could still harm others, and it's necessary to create this kind of exception. I further, the proposed definition of a less lethal device would be unworkable in the field that we're in." And so let's be able to try to work through this and make a device that clearly works on what we would like it to do, is to de-escalate, to save lives, to not put the beloved, if I might, son of Lucy Macbeth in the dangers that so many are put in. This is where I want to leave my last quote. That's who I'm concerned about. And that's who many who are in this room are concerned about. And so I ask unanimous consent to put those in the record. I think I heard
Yeah, I already said without objection.
I'd be happy to yield, madam. Let me yield back to the gentlelady from Vermont, please, at this time.
Thank you. I just want to be clear, based on everything that I've heard so far, this bill has very little to do with law enforcement, and the only place it even says law enforcement is in the title. And law enforcement officers are already exempt from the Gun Control Act and can obtain any kind of firearm, including those that are designed to be less lethal. The bill also has no definition of projectile, so the loophole it creates would apply to weapons that shoot any ammunition, including bullets, as well as weapons that could easily be converted in a standard gun. So it seems at its core to be a boondoggle for manufacturers of less than lethal weapons. And I don't think it makes us or law enforcement any safer. I yield back.
Does anyone else seek recognition?
It's your time. You don't have any time?
She was done. Mr. Klein?
I'll move to strike the last word. Madam Chair, I think that this bill is self-explanatory. It's designed to incentivize the use of weapons, tasers, that are less than lethal, that will help to de-escalate situations in which law enforcement officers may find themselves. We all want to support our law enforcement officers and make sure that they are, when in a situation, able to de-escalate, but also protect life and, most importantly, equally importantly, their own lives. So to protect themselves from whatever circumstances they may be facing, but also to potentially engage someone in a less than fatal manner. So when you have what my understanding is state laws that are all over the map on this, regulating these types of items, and then ATF classifying it as a taser as a firearm, you have confusion in the law that needs to be clarified. This bill would clarify that. It would save lives. It would improve law enforcement's ability to de-escalate situations and keep communities safer. So I urge support for this common sense bill. I yield back.
Does anyone else seek recognition? Yes, Ms. Macbeth from Georgia.
Thank you, Madam Chair. At this time, I'd like to yield my time to my colleague in Georgia, Mr. Hank Johnson.
I thank the gentlelady for yielding, and for purposes of unanimous consent, I would submit into the record a letter dated November 23rd, 2021 from the U.S. Department of Justice, Bureau of Alcohol, Tobacco, and Firearms and Explosives concerning a Taser 8, which was submitted to the agency by the manufacturer to determine whether or not...
Without objection.
Thank you. And this taser was submitted for purposes of determining whether or not it fell under the federal definition of a firearm, and the finding was that it did. And so now this bill, once it's renamed in accordance with my amendment that I'm going to make, which would rename it the Make the Gun Lobby and Gun Manufacturers Happy Act. Once we adopt my amendment so that the bill is no longer misnomered, I'm still going to vote against the bill and ask my colleagues to do the same thing, because it creates a giant loophole that would also apply to some weapons currently classified as destructive devices, which cannot be possessed by civilians in some states. That means that some devices would move from being accessible only to law enforcement to being accessible to anybody, including convicted violent felons, domestic abusers, and other prohibited purchasers, without any background check, without a traceable serial number, and without any other regulation, and they could put it on a drone, as my colleague from, I believe, Arizona mentioned, put it on a drone and have it shooting at people from the sky above. And this is significantly undermining of state efforts to protect law enforcement and communities by prohibiting the possession of destructive devices in those states. And with that, I'll yield back to the gentle lady from Georgia, Ms. McBath.
Thank you. I'll now yield the balance of my time to my esteemed colleague from Texas, Sheila Jackson-Lee.
I thank the gentlelady from Georgia, and I make just a simple point. The times that we have come into this hearing room, and I've been here more often than not with Chairman Nadler, now recently Chairman Jordan, it has been over the massacre of children. I remember, I believe the first time was Columbine. And we have had Texas Tech, Sandy Hook. We have had the massacre in Florida, Parkland. I remember running from Washington when it was regarding the little ones in Texas. And then the other target has been churches. We've lost loved ones who were worshiping. And they were worshiping together. And they were worshiping in harmony and peace. We could not separate them. They were worshiping. And so I want to leave with the colleagues who may have an inclination to vote for this. This will make it better. And just to remind them, better for what? I can't imagine that loss of life with children or worshipers as we begin, I believe, Passover. And then to deal with the fact that we're in school and a lot of these incidences would happen at the end of school or beginning of school. We have no answer to this question of whether or not this device is now better. I say it is not. I say it is wrong-headed and it is the wrong direction. And I ask my colleagues, as they think about a device that is going to be better, ask for whom, for what purposes, and if they cannot answer where there is a decided seismic change, vote no against this bill. I yield back. Madam Chairman.
The chair recognizes Mr. Bandrew from New Jersey.
Thank you, Chair. I don't understand what we don't understand about less than lethal. It's just those words, less than lethal. The Gun Control Act was never meant for tasers. And law enforcement can't use it when they want to, especially this new technology, in less than lethal situations. It's just another way, another time, another incidence when we're making life more difficult for those who would protect us, and keep us safe. And we say we want to use less than lethal means, but yet we would not allow it. I don't understand where the other side's coming from this. It's less violent. You know, if we really worried about these issues, we shouldn't constantly inflict pain and make regulations just to hurt police or just to hurt those who are legal gun owners. The problem aren't the police. The problem isn't those who are legal gun owners or legal taser owners. They're just trying to do the right thing, and it gets old. You know, if we want to make it better, and it's the same tune, but it's really important. Why don't we close our borders where we have millions of people coming over? We don't know who they are, where they're going, what they're doing, tens of thousands of Chinese nationals, etc. I'll go on, Venezuelans, people on the terror watch list. That's how you make it better. You don't take another way for police to protect others and themselves that is less than lethal away. And how about we just close the border instead? Maybe that would make more sense instead of hurting police. How about we enforce the rule of law? If we're worried about people when they worship, I am too. In this committee, we heard when the FBI was going to, in my mind, illegally go into Roman Catholic churches and school boards after people who were legal but thought differently or acted differently than they did. How about we obey the rule of law? How about we have cities that obey the rule of law? How about we stop the crime? How about we stop the revolving door where people are out over and over and over and over again until they hurt somebody or kill somebody? How about we do all those things? But instead, we debate over trying to make life more difficult for people that have an unbelievably difficult job trying to keep us safe. Come on, let's be on the right side of an issue. This is the right side of the issue. This should be a no-brainer. I yield back.
Gentleman yields back. Who seeks recognition? I recognize myself for unanimous consent to submit a letter from the African American Mayors Association stating that they represent the African American mayors in the United States, and they believe that Congress's enactment of this bipartisan bill is the utmost importance for the safety and well-being of our constituents and cities. Without objection. The question is on adoption of the amendment in the nature of a substitute, and this will be followed immediately by a vote on reporting the bill. All those in favor say aye.
Aye.
Those opposed say no. In the opinion of the chair, the ayes have it. And
Parliamentary inquiry. Have we checked to determine whether or not that letter from the African American mayors is a forgery or not?
in the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted.
Under the ANS. That was the ANS? That was the ANS.
The ANS. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye.
Aye.
Those opposed say no. The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to...
Are we hearing a recorded vote? No, we're not hearing a recorded vote from us.
Sorry.
Okay.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute incorporating all adopted amendments, and staff is authorized to make technical and conforming changes. Where are we? Next one. Is that 1630?
Just flip the page over. Not quite yet.
Pursuant to notice, I call up H.R. 7581, the Improving Law Enforcement Officer Safety and Wellness Through Data Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 7581 to require the...
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes the gentleman from North Carolina, Mr. Bishop, for an opening statement.
I thank the chairwoman. And I'm pleased to co-sponsor this legislation, H.R. 7581, with bipartisan sponsors in the House. There is a companion bill in the Senate, also bipartisan, and in which Senators Grassley and my colleague from North Carolina, Senator Tillis, are co-sponsors. It is the Improving Law Enforcement Officer Safety and Wellness Through Data Act. This legislation is meant to help our men and women in blue. Police officers risk their lives every day to protect our communities. Unfortunately, they face the continued threat of unprovoked attacks. The defund the police movement continues to have ripple effects throughout the country as violent crime increases and criminals become more brazen in their attacks against police officers. In addition, Soros prosecutors and progressive bail reform policies, usually legislated from the bench, continue to allow more criminals on the street with no accountability. Let me be clear. The threat to officer safety is very real. In 2023, 378 officers were shot in the line of duty. 115 of those were ambush-style attacks, the highest amount the Fraternal Order of Police has ever recorded. That is obviously unacceptable. Just a few weeks ago, we saw the senseless killing of young officer Jonathan Diller in New York City, a life taken much too early by yet another criminal who should not have been on the street. We pray for his family, especially his wife and the one-year-old son he left behind. There are other notorious recent examples. David Dorn, killed in June 2020, a 77-year-old retired police captain, fatally shot while interrupting a burglary in St. Louis during the George Floyd riots. Ned Byrd, a sheriff's deputy in Wake County, North Carolina, shot to death by illegals, apparently ambushed as he was in his vehicle late at night. Sergeant Philip Dale Nix of the Greensboro, North Carolina Police Department, killed at a Sheetz gas station, confronting 3 persons stealing beer in bulk from that convenience store. Robeson County, North Carolina deputies Jonathan Walters and Kalen Locklear just a month or so ago badly injured, shot both of them multiple times before one of them was run over by his own car in a shooting trying to retake custody of a 2 times prior arrested suspect, once for armed robbery and then for first-degree murder, and let out on the streets after both. And Ryan Hendricks, just a couple of weeks ago, I was in Henderson County, North Carolina. Henderson County Deputy Ryan Hendricks killed in 2020, taking on a savage shooter who was intent on doing harm first to a family and armed with a weapon, shot Ryan Hendricks in the face, killing him just a month short of his wedding date with his fiancée. While the government collects basic information on these attacks, such as when the attack occurred and what types of weapons were used, more information is needed to help law enforcement officers prepare for, identify, and prevent future anti-police activity. Just a couple of examples of the items in the bill that would be sought as additional information. It's like the number of offenders that intentionally target law enforcement officers because of their status as law enforcement officers, or the number of incidents reported to the law enforcement officers killed and assaulted data collection that occur through the coordinated action of 2 or more parties, for example. The bill also would report on, require an evaluative report on the prospect of expanding the Uniform Crime Reporting System and National Incident-Based Reporting System to include systematized reporting of aggression against law enforcement officers and trauma-inducing incidents that law enforcement officers endure. It would also require a report on mental health and wellness of police and resources available to them for mental health help. Mental health resources are another crucial tool in the toolbox as law enforcement officers continue to risk their lives every day to keep their communities safe. We must take care of those who do so much to take care of us.
Madam
This
Chair,
legislation is common sense.
the clock is not running, Madam Chair.
It's the opening statement, I believe.
All right, I'm sorry.
Yes, sir.
The opening statements are untimed in the committee.
This legislation is common sense. It looks to gather more information on an issue to then bring forward the best possible solutions for our law enforcement officers. Let's all work together to take a stand against attacks on law enforcement and to support our men and women in blue. I thank you, and I yield back.
Thank you, Mr. Bishop. And the chair now recognizes the ranking member, Mr. Nadler, for an opening statement.
Thank you. Madam Chair, this bill purports to improve law enforcement officer safety and wellness. It seeks to do this by requiring the Attorney General and other federal officials to issue reports about attacks on officers, aggression against officers, and officer mental health. While this legislation may seem meaningful, it is really just more cheap talk from Republicans. Nothing in this bill makes a single police officer safer or invests resources in officer wellness. While the collection of accurate data, including data on officer attacks and mental health, is important, this bill is unlikely even to provide new meaningful data. By necessity, data about incidents of violence against law enforcement officers must be initially collected and reported, if at all, by tribal, state, and local authorities who would know about these incidents, not the Attorney General. The federal government collects this data through the participation by these authorities in voluntary data reporting programs like the National Incident-Based Reporting Program and the Law Enforcement Officers Killed and Assaulted data collection. But nothing in this bill provides any resources for more agencies to participate in those data collection programs, nor does it mandate any kind of reporting. Given that there is nothing in the bill to improve the underlying data that is available to the Attorney General and others, it is unlikely that the reporting required by the bill will be able to deliver any new insights that might improve officer safety. Democrats sought to solve this basic problem of inadequate data collection through the George Floyd Justice and Policing Act. Under that bill, states would be required to report shootings, deaths, and other uses of force involving law enforcement officers, and states would receive grants to facilitate that reporting. By both mandating and supporting data collection and reporting, the George Floyd Justice and Policing Act would significantly improve the data available to the Congress, federal agencies, and the public. Critically, unlike this legislation, that bill would require reporting of uses of force both by and against law enforcement, enabling us to have a full understanding of the dangers faced by officers, as well as the injuries and deaths of civilians caused by police. In focusing only on attacks against officers, this bill turns a blind eye to uses of force by law enforcement against civilians, whether justified or not. The mental health reporting provisions of the bill are also unlikely to improve officer wellness because they fail to build on the work of past Congresses and the Biden administration. In the 115th Congress, we passed the Law Enforcement Mental Health and Wellness Act, a bipartisan, bicameral bill signed into law by President Obama, which directed the Department of Defense, the Department of Veterans Affairs, and DOJ's Office of Community-Oriented Policing Services to report on mental health practices and services that could be adopted by law enforcement and the programs already available to them. It also expanded the availability of grant funds for law enforcement mental health and developed new educational resources. Building on this work, President Biden issued a 2022 executive order on advancing effective, accountable policing and criminal justice practices to enhance public trust and public safety. The executive order required the Attorney General to develop and publish a report on best practices to address law enforcement officer wellness and to make recommendations regarding the prevention of death by suicide of law enforcement officers. The Attorney General has already complied with this executive order, so we already know much more about the mental health resources and needs of law enforcement. Rather than retread our steps, we should be moving forward to help our law enforcement agencies implement this important work so that more officers can access the support they need. Last Congress, Democrats passed numerous bipartisan bills that improved law officer safety and wellness, like the Protecting America's First Responders Act, the Public Safety Officer Support Act, the Confidential Opportunities for Peer Support or COPS Counseling Act, and the Law Enforcement De-Escalation Training Act. And at least 7 bipartisan law enforcement bills, many led by Republicans, have been passed by the Democratic-led Senate and are awaiting consideration in the House. These are bills that would actually help law enforcement and are priorities for the police groups, but House Republicans refuse to move any of them. While they failed to work with law enforcement organizations to pass meaningful legislation, Democrats will continue to work with these organizations on substantive proposals that will make our communities and law enforcement officers to protect them safer. Thank you, and I yield back the balance of my time.
Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from North Carolina for the purpose of offering an amendment in the nature of a substitute.
Madam Chairwoman, I have an amendment at the desk.
The clerk will report the amendment.
Amendment in the nature of a substitute to H.R. 7581, offered by Mr. Bishop.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered base text for the purposes of amendment. The chair recognizes the gentleman from North Carolina to explain the amendment.
Thank you, Madam Chairwoman. This amendment makes a small change in the short title and does nothing to alter the substance of the bill. I yield back.
Thank you. And who seeks recognition?
I do, Madam.
The gentle lady from Texas, Ms. Jackson. You are recognized for 5 minutes. Thank you.
Thank you, Madam Chairwoman. As the ranking member of the Crime Subcommittee, I am disappointed that this legislation is how Republicans are choosing to use our time again. There is so much that we could do to actually help law enforcement, particularly as we come upon this month, the month of May. As this bill notes, law enforcement officers face significant challenges, and to help them now, daily, is something we all desire, and to do it every day. Every day, our federal, state, tribal, and local law enforcement officers put their lives on the line to do this important work and more. But today, instead of focusing on providing law enforcement agencies with the tools and resources they need to make their dangerous jobs as safe as possible, we are spending this committee's limited time on a bill that, despite its tribes, will not make a tangible difference in officer safety or wellness. This bill offers to collect information. While that information might be useful, much of it is already collected. I should point out that this bill would collect much less information on police encounters than would be collected under the George Floyd Justice and Policing Act, bipartisan legislation which the House has already passed twice in previous Congresses, and which I plan to reintroduce soon, which is soon to be introduced, soon. Under the George Floyd Justice and Policing Act, states would be required to report uses of force by or against a law enforcement officer, valuable data that would enable us to craft policies to make everyone safer. Unfortunately, this bill fails and falls far short of that objective by only requiring Attorney General to provide reports to Congress, and those reports will likely not have any more information than already collected by DOJ. Lastly, I want to note that we have met with several police groups about many bills that we believe would actually help make this safer and improve the well-being of the officers they represent. This includes several Republican-led bills that have already passed the House and the Senate. For instance, the American Law Enforcement SAVER Act, which would establish standards for trauma kits used by law enforcement and establish best practices for using these kits. The majority could schedule votes on this and other bills right now. Instead, we are considering a bill that takes a step backwards from the meaningful reporting mandates in the George Floyd Justice and Policing Act and falls short of the substantive bipartisan agreements we were able to reach on other legislation in past Congresses. Let us work together. I've already said our priority should be our children, our seniors, and those who have been in this fight for a long time. When Democrats regain control of the House, We will invest in the tools, training, and resources that actually support the challenging work of our brave law enforcement officers across the country. Until then, I urge our Republican colleagues to work with us and law enforcement on meaningful improvements that we each achieve together, which this bill is not. I would hope that we would bring all of us together on meaningful improvements that we can achieve together. This bill does not do that. So I thank the chairman, and I thank those who are truly dedicated and committed to working for meaningful, safe, and secure law enforcement tactics and tools. Until this, I urge our Republican colleagues to work with law enforcement on meaningful improvements that we can achieve together. Again, this bill does not do that. And I thank the chairman, and I yield back to get us to a point where we're working in a meaningful manner to save lives. I know we've got it in us. I've seen it happen, and I'm ready to do it today. With that, I thank the chairman, and I yield back.
Who seeks recognition? Mr. Bishop.
Thank you, Madam Chairwoman. You know, I began the opening statement on the bill, thank you for yielding to me to offer that, by pointing out that this bill is bipartisan in both chambers. And it is the Judiciary Democrats' extreme hostility to police officers is disheartening, but it ought not deter the committee from taking the action set forth in this bill. I understand, of course, that those who have, you know, were the origins of the defund the police demonization and delegitimization of police officers prefer the George Floyd Anti-Police Act and the other legislation mentioned by my colleagues on the other side of the aisle about imposing de-escalation burdens on those who are confronting deadly force and the like. And it is true that this bill focuses singularly on one problem, the increasing prevalence of ambushes on those who are trying to protect us. And I gave both numerically the fact that we've hit a peak in that in the FOP tracking, and I gave a number of examples that ought to chill every American to the bone. But that doesn't move my colleagues on the other side. I understand. I will say also it is a data collection exercise, a reporting exercise, and if the worst that can be said by my Democratic colleagues is that it doesn't produce any information or insights that we can use in order to combat this scourge, very little is lost. It certainly will not, for example, go and sweep away a century or more of qualified immunity law that would, whatever's left of the environment for policing in the country, where officers are increasingly being intimidated into stepping back from helping and saving people on that thin blue line. You know, we don't. This bill would ask for data and seek to collect it and improve the data set that is available to policymakers to determine what can be done to keep young officers with one-year-old children at home from being ambushed as they are in a car or at a traffic stop. And I think that to be well worth doing. I understand that's not universally shared, and the most extreme forces in our politics will object to doing that, but not all. And so we have bipartisan participation as sponsors on this bill. I trust we'd have bipartisan support if and when it comes to the floor. And I mentioned not only bipartisan, but bicameral. So with that, Madam Chairman, I'll look around if anyone else wants to take my time, but having said everything I need to at this point, I'd yield back.
Thank you. Who seeks recognition? The gentleman from Georgia.
Thank you, Madam
You're
Chair. I have
recognized
an
for
amendment.
5 minutes.
I have an amendment at the desk.
Reserve a point of order.
The clerk will report the amendment. And the gentleman reserves a point of order.
Amendment to the amendment in the nature of a substitute to H.R. 7581 offered by Mr. Johnson. Page 1, strike line 5, and all that follows.
Without objection, the amendment is considered read.
Thank you,
And the
Madam.
gentleman is recognized for 5 minutes.
Thank you, Madam Chair. Following the standards set by the bipartisan George Floyd Justice and Policing Act, which my colleague, Congresswoman Jackson Lee, just reintroduced today after it had passed twice the House, last term and the term before that. But my amendment following that standard would provide stronger reporting requirements that could truly improve law enforcement officer safety and wellness through the collection of data. Like the George Floyd Justice and Policing Act, my amendment incorporates the Police Reporting Information, Data, and Evidence Act, or the PRIDE Act, led by Congressman Joaquin Castro, my colleague and fellow member, well, he used to be a member of this committee. My amendment would require states to report any incident that involves a law enforcement officer shooting or seriously injuring a civilian. It would also require states to report officer deaths of civilians in custody, and incidents involving the use of deadly force against civilians, mandating that such data is collected while also providing states and localities with the resources to fulfill the mandate would provide us with a wealth of information that could be used to develop informed, evidence-based policies that make law enforcement officers safer, as well as the civilians they are sworn to protect and serve. Several states have already passed similar legislation. According to the National Conference of State Legislatures, at least 26 states have enacted 46 bills related to data collection and transparency since May of 2020, including many states. I ask that this amendment be voted on and approved by this subcommittee. I would point out that this bill that we're currently considering provides not a single penny an investment in officer wellness, and it does absolutely nothing to make officer safety. I ask that my colleagues support this amendment and help save officer and civilian lives, and with that, I yield back.
Who seeks recognition?
Madam Chairman, I do.
Mr. Bishop?
I insist on my point of order, Madam Chairwoman. The subject matter of, this is very much along the lines of what the early opening debate was on the bill. The Democrats prefer a different bill, a different subject matter. This is not about collecting data about ambushes and assaults and violence against police officers. It's about collecting something else. Now, the gentleman makes an argument that that somehow doing all this about officer-involved shootings and a variety of other things could somehow make officers more safe. Well, that would be the only and quite a very tenuous connection, and I think not at all. It's an entirely different scope of legislation than the bill that has been offered.
Does the sponsor wish to be heard on the point of order?
Yes, I do. Madam Chair, this amendment has to do with additional reporting requirements that would be required of law enforcement agencies and officers, same as is called for under the underlying legislation, but actually expanding it to include information that would enhance safety, not just for law enforcement officers, but for the public as well. And it's certainly related to the underlying legislation.
The gentleman yields back.
And with that, I yield back.
Well, may I rise to speak to the point of order?
The chair recognizes the gentlewoman from Texas.
Well, first of all, we're in the room to talk about guns and talk about safety. Certainly, the gentleman's amendment does that. This legislation that we have before us falls far short of the George Floyd Justice and Policing Act, which requires the requiring of ages of force, uses of force by or against a law enforcement officer. That's the core of what we're doing in this committee room, and how we pretend to be safe, and how we pretend to be safe for these children and the protected population that we're talking about. The GFJPA reporting includes officer shootings by civilians, officer deaths, deaths of civilians in custody, and use of deadly force against civilians. In focusing only on attacks against officers, this bill turns a blind eye to uses of force by law enforcement against civilians, whether classified, whether justified or not. It seems limited and too narrow to be able to be comprehensive of what our duties are in this committee. House Republicans are again refusing to work with police and the organizations that represent them to pass meaningful legislation. Democrats continue to work with law enforcement organizations on substantive proposals we will pursue when we take back the House. At least 7 bipartisan law enforcement bills, many led by Republicans, have been passed by the Democratic-led Senate and are awaiting consideration in the House. These are the bills that would actually help law enforcement and are the priorities for the police groups that we have been working with, and we have been working with them on a daily basis. These are bills that would actually work with us and that we are working with them. So I believe that the gist of what the work that we're doing as House members is well contained within the gentleman's amendment, and that his amendment is germane, and that his amendment should be committed under, if anything, general background. This legislation would require reporting related to attacks on law enforcement officers, aggression against officers that fall below the level of an attack, and officer mental health. The bill refers to several existing reporting requirements and federal programs explained below. So I frankly believe, I'm not sure how we've stretched it to say that it's not germane and it's not in order. The FBI Uniform Crime Reporting, UCR program, collects data from more than 18,000 city, university, and county, college, county, state, tribal, and federal law enforcement agencies. Agencies participate voluntarily and submit their crime data either through a state UCR program or directly to the FBI's UCR program. The FBI annually publishes a report, law enforcement officers killed and assaulted, the LEOKA program, to provide information about officers who were killed intentionally or accidentally, and officers who were assaulted while performing their duties. The FBI collects data and does the work, and we're out on the front lines trying to save lives for the people every day. And I want to say that the gentleman's amendment is germane because he is dealing with those on the front line every day. And I thank the gentleman, Mr. Johnson of Georgia, for very important data collecting materials.
Madam Chairwoman, in light of the chair having entertained extended debate on the issue, I'd like to be heard again on one other grounds that sustains the objection.
The chair recognizes Mr. Bishop.
On pages 7 and 8 of the proposed amendment, there is a provision that would impose a 10% reduction of the funds otherwise allocated under the Byrne Grant Program. There is no corresponding subject matter in the bill. And also, it was mentioned just now in debate on the objection that there are a number of organizations that endorsed or supported the other legislation that is being referred to and essentially being offered to gut and replace this bill by this amendment. I didn't mention that in my previous argument, but this bill is endorsed by the Fraternal Order of Police, the National Association of Police Officers, the Peace Officers Research Association, Sergeants Benevolent Association of the NYPD, Federal Law Enforcement Officers Association, Major County Sheriffs of America, the National Police Association, the North Carolina Fraternal Order of Police, North Carolina Sheriffs Association. So that's not a distinction, but it also doesn't go to the issue at hand. So I insist on the point of order.
Thank you. The chair is prepared to rule. I would also note that this is offered not as background, but as a wholesale substitute. The gentleman's amendment does not satisfy the subject matter and fundamental purpose tests, and therefore it is not germane and is out of order. Who seeks recognition?
The gentleman from Maryland.
The gentleman from Maryland, Mr. Ivey.
Thank you, Madam Chair. I want to say this to my friend from North Carolina. I appreciate your sincerity on this issue, and I respect you greatly. I got to say, though, I have a different view on some of the things that you said. I particularly struggled with the defund the police comments because as I've heard it in this committee, the only people talking about defunding law enforcement are Mr. Gates. I think he has a bill to do that with respect. I can't remember if it was ATF or FBI. Ms. Green had one for the other law enforcement branch, but nobody over here is calling for the defunding of law enforcement. But to the particular matter here at hand, I served for 12 years as a prosecutor, 4 federal, 4 state. Prince George's County had a long history and a troubled history of police excessive force. We also had high crime issues. And so when I took office, I was sort of thrust into the position of having to prosecute police officers who went too far, and I did. I also had to handle cases in which police officers had been killed. And in one instance, as Mr. Bishop references, it was an ambush in which 2 officers were killed, 2 deputy sheriffs were killed. So this is very serious business for me, and I take it very seriously. One of the things I think is important for us to recognize is, yes, we do need to collect data because legislation that we put out should be data-driven. I think there was a comment I made on a previous bill today that had no data background, but our Republican colleagues decided to move forward with it even though there was no factual basis to do so. Here, as I think the ranking member pointed out, there's already data collected on these sorts of matters. And then with respect to the amendment that was just ruled to be non-germane, I think it points out the fact that we don't have comparable data that's collected with respect to use of police force, excessive force. And so the challenge that creates is for jurisdictions across the country trying to figure out ways to address problems of excessive force. We don't have a great database for doing it. And it's a little bit ironic that the bill right before this one was a taser bill. And it wasn't a bill just to justify tasers, because tasers are already allowed, but to justify an increase in the power of the projectiles generated by tasers and justify a legislative change in the Section 921 and 922. Look, I think it's important for us to understand a couple of things. One is there are challenges on both sides of these issues. We have police officers who are being killed in the line of duty. We absolutely need to take that very seriously. As I said, I prosecuted cases like that. In some instances, those were first-degree murder cases. I also prosecuted cases where the police used excessive force, and in one of those cases, the officer was convicted and sentenced to 45 years in jail, and rightly so. So let's try and be serious and balanced about this. I mean, I think it makes sense to collect the data. I would suggest in this particular bill that we try and collect data that we're not already getting with respect to police officers and violence against them. I'd be fine with that. I think it's also beyond clear that we need to collect evidence with respect to the police use of force, whether it's excessive or not, can be determined after you collect the information. But then it would allow us to make the decisions on a factual basis like the ones we just made with the previous legislation. And then on the last point I would make with respect to the mental health provision, police officers have maybe the toughest job in the world right now, with the possible exception of our military. We've got people, and Mr. Bishop, you're on Homeland Security just like I am. You heard Border Patrol come in and say one of the top things they wanted was additional mental health provisions to be provided for them so they could get the help that they need. And I don't mind collecting data on that, but I think the ranking member made this point. Let's actually get the services to them. You know, so your bill, fine, okay, but let's put in the money, let's get the resources. I know there's some things afoot already. I think there was a reference to one of the White House executive orders. But let's get them what they need now, because the challenges are there now. There are people who need the help now. Let's get them the assistance now. And that might not be in this bill. I'd be willing to work with you on a different piece of legislation. I'm going to vote no on this. And I apologize for running over, Madam Chair, but with that, I yield back. And I thank all of those on the committee for bringing a sincere approach to this legislation.
Who seeks recognition? The question is on adoption of the amendment in the nature of a substitute, and this will be followed immediately by a vote on reporting the bill. All those in favor say aye. Those opposed say no. In the opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. A reporting quorum being present, the question is on favorably reporting the bill as amended. All those in favor say aye. Those opposed say no.
No.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment in the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes.
Did you voice voted? Yes. Okay.
Just for committee members, it's the intention of the chair. I was hoping to catch Mr. Klein, but I think what we'll do is recess the committee one more time, and we'll come back tomorrow at 10. We have one more bill that I do want to get to this week, the one agency legislation, which I assume is going to have some debate and maybe some amendments. So the plan is to recess, and we will be back at 10 a.m. tomorrow. I think we're going to be here most of this week anyway. So with that, the committee stands in recess.